Everyone, a very good afternoon to all of you. Today is a very special day, as you all know. It's CA Day, so best wishes to all of you, our future chartered accountants. You have already, taken one step by enrolling into this course, and you are studying for this CA Foundation examination. So already you are there in the your roadmap is already set, so you will be sooner or later you will be becoming chartered accountant. So best wishes to all of you. And also, since we are studying the sale of goods act, if you all remember, what is the date of commencement of the sale of goods act? Can anyone tell me? It's 1st July 1930. So again, it's the birthday of Sale of Goods Act also. So it has been, see, around 97 years since this Sale of Goods Act has been enacted. And we are studying that. Okay. So I hope you all are getting whatever we have studied so far. We have covered half of that portion. The total Sale of Goods Act is divided into 4 units. We have already covered first 2 units, wherein we have discussed how this contract of sale is formed, and then what are the conditions and warranties related to that. So first 2 portions have been covered. Last 2 units, which will tell you basically what it is, or basically how the ownership is transferred. So ownership related topic we will be discussing today, that is contained in unit 3. So again, we will have 2 sessions for unit 3. Plus, there are some other rules for delivery, and a very important topic, the circumstances when even a non-owner can sell the goods. So normally the rule is that only the owner can pass on the better title. So better title simply means that if I have the ownership, I can transfer my ownership to someone else. But if I am myself not the owner, how can I pass it on to others? So normally the rule is the person who is the owner, who that person can only transfer the ownership. But there are some exceptions to it, and we will discuss those exceptions in detail in unit 3 itself. Okay, and then uh, we will discuss the whole topic of unpaid seller. What are the rights with respect to unpaid seller in the last unit, that is unit 4. So we have to, understand it in the wholesomeness. I mean, everything we have to understand from the very beginning till the end. What are the rights of buyer? What are the rights of seller? And everything related to that. So that is what the whole Sale of Goods Act will cover. So Jyoti is asking, what is the difference between express and implied? Express is basically when you discuss it in uh, discuss when both the parties discuss either verbally or they have it in writing. So express conditions or warranties will be which are discussed, mutually discussed between the parties. And if you are not discussing anything, but still those conditions are applicable or still those warranties are applicable, these are through the act. So whatever is contained in the act, that is automatically applicable on you. So whenever we say something is automatically applicable, it is basically implied by law. So we do not have to discuss about that. It is automatically applicable, right? So that is what is contained here in when you are asking about the difference between express and implied. So are we all ready to start the new topic? Are we all ready to start the new topic, unit 3? Okay. So everyone is ready. I'm getting a lot of yes in the chat box. So let me quickly start the presentation, because this is a very detailed topic and it requires your complete attention, your complete focus. I hope my screen is visible. Just let me know if my screen is visible, please. A lot of questions can be asked in exam from this chapter. Yes, so thank you, Dakshita. Thank you, Akshit. My screen is visible to you. So I'll just start this unit 3 with all of you. Okay. So here we go. The name of this unit is basically transfer of ownership and delivery of goods. So we will be discussing broadly 2 topics. First is when the ownership is transferred and who is the actual person who's transferring the ownership. Then whether the owner can transfer or non-owner can also transfer the ownership. All that is contained in this first part, transfer of ownership. Then we will discuss about the delivery of the goods. See, we have discussed the definition of delivery, definition of goods in the first unit itself. But there are some rules related to delivery of goods. How delivery should be made, or what is the time of making the delivery. What if the delivery is not made in that particular time period, or if it is not done in the complete set, whatever was discussed or whatever was decided. So if there is incomplete delivery or there is some inconsistency in the delivery mechanism, then what all are the rules related to that we will study in detail when we will be discussing this topic of delivery of goods. So if you can see here how many sections we will be discussing in this total unit, it starts from section 18 and it goes on till section 44. So this is the longest chapter, or you can say it will contain so many provisions, and it is covering the major portion of your Sale of Goods Act. So let us start. Don't worry about the section numbers. We will understand everything. And wherever the sections are important, I'll let you know so you can remember it that way. So after studying this whole unit, what you should be able to finally understand. So this is the content for the unit, which you must be able to uh, understand. At the end, I mean, you should be able to answer each and every of these questions. So the first thing is, how and at what point of time the ownership in goods, which are the subject matter of a contract of sale, passes from buyer to seller. So when we discuss everything, you should be able to understand at what point of time ownership passes, whether it passes immediately or it passes at a future time. What is the scenario? So you should be able to understand that. Next, about what appropriation of goods is and how it affects the passing of property in goods. So you will understand this new term again, appropriation of goods. What do you mean by appropriation of goods, and how does it impact or how does it affect the passing of the property? Wherever the term property is used, it means, wherever the term property is used, what does it mean? Can you tell me in the chat box, what does the property in goods means? It means the ownership in the goods. Very good. Vishnu, Yukti, you all have told correctly, I mean, Dakshita. Yeah, it's the ownership, it is the title. So wherever the term property is used, it is basically, we are discussing about the ownership of the goods. Okay. Next is the distinction between passing of property and passing of title. Okay, and then this Latin phrase which we have, nemo dat quod non habet. So this simply means no one can give a better title than he himself has, and there are some exceptions to it. So I'll be taking this in detail later, so I'll not discuss it right away, but it simply means that sometimes there are some circumstances wherein even a non-owner can pass on ownership. So just let me take a quick example. An agent can sell the goods on behalf of the owner. So like just a salesman, he can sell the goods on behalf of the owner or the manufacturer of the goods. Okay. And in Sale of Goods Act, we normally call him mercantile agent. Okay. Next is the rules relating to the delivery of goods and the acceptance of goods. So everything we will be discussing in detail. So let us start with the first topic. A contract of sale of goods involves transfer of ownership in basically three stages. So these are the three stages wherein the ownership, is involved, or how it passes on to the next person. So section 18 to 25, basically they talk about the passing of property. Then next set of sections, that is starting from section 31 to 44, they talk about delivery of the goods. And then section 26 that has been separated, and this will be discussed in detail. So it talks about passing of the risk. So ultimately, whosoever is the owner will bear the risk. Whosoever is the owner will bear the risk, and that is what is contained in section 26. So the general rule is risk prima facie passes with the property. So whosoever owns the good will bear the loss. So if you are saying seller is the owner, seller will bear the loss. If you are saying buyer is the owner, buyer will bear the loss. So ultimately, we have to decide who is supposed to bear the loss. Okay, we will discuss each and everything with the help of examples, but this was just in a nutshell what all we will be discussing. Okay, let's move further. This is the introduction part, and we are starting with the first thing, why the time of transfer matters at all. I mean, this question should come to your mind also. Why we are discussing all of this? Why this time of transfer matters? Because if we are assuming that the ownership is basically the deciding factor for the risk, who will bear the risk? Owner will bear the risk. So therefore, it is very important to understand at what point of time the ownership passes. So by the time seller is the owner, he will bear the risk. And as soon as the ownership passes to the buyer, from that point of time, he will bear the risk. So that is what the main thing mentioned here is. So sale of goods involve transfer of ownership of property from seller to buyer. It is essential to determine the time at which ownership passes because, because of these four consequences which are there. So what are the four consequences? Let us discuss that. Why is it very important to understand the time of transfer? When does this transfer of ownership takes place? Why is it very, very important to understand? These are the cases. Okay. So the first point is risk follows the property. Whosoever is having the ownership, it is his or her risk now. So if you want to really identify who will bear the loss, who will bear the risk, you have to know who is the owner. So therefore, we must understand what is the time when the ownership passes. So I'm just reading it from here. The general rule is that risk prima facie passes with the property. If goods are lost or damaged, the loss is borne by whosoever is the owner at that particular moment. So risk prima facie passes means risk primarily passes with the property. So wherever this prima facie term you see, it means primarily. So risk normally or risk primarily passes with the ownership. So whosoever is the owner, risk will be of that person. So let me just tell you one example here itself so that it becomes easy for you to understand. Suppose I purchase this mobile from the shop. So as soon as I made the payment and I had this mobile with me, this mobile's ownership has now been transferred to me. Earlier, who was the owner? Shopkeeper was the owner or the seller was the owner. But as soon as the payment was made and he delivered the goods to me, I have become the owner. So the ownership has been transferred maybe at the time when I was standing in the shop itself. So in the context of sale, immediately the ownership transfers. As soon as you enter into a contract of sale, immediately the ownership passes. So in case of sale, it passes then and there. In case of agreement to sell, it takes time and it passes on later. So while coming back to my home, maybe if this phone is stolen, or suppose by chance I dropped it and it has, it has got some cracks or anything, any mishappening has happened to this, and a lot of damage has happened to this phone. Who will be responsible for it? Who will bear the loss for it? Buyer will bear the loss. I cannot complain to the seller regarding the quality of the mobile or anything later on, because now I am the owner, I have to bear the risk. So that is the first point. Second point is action against the third party. It should be noted that only parties to a contract can take action on each other, and if you are the owner of any goods, then if any third party is coming into picture, you can take action on them. So let me just read it and then we will understand it with an example. Where goods are damaged by the act of a third party, it is the owner who can take a legal action. And here it is clearly mentioned that only an owner has the right to take the action against the third party. So suppose this particular mobile was taken away by some other person. Can I file a complaint against that person? Can I file a suit against that person? Yes, I can do so because I am the owner of this mobile. Can seller do that on my behalf? No, seller cannot do because he is not the concerned person or he is not the owner basically. So, and even I am not giving in any right to do so. So it is basically in law, it is mentioned that only the owner has the right, or owner has the authority to file the suit on the third party. Third party means other than buyer and seller. If anyone else is into the picture or anyone else is doing anything, then you can file a suit on him if he is doing anything wrong. Next, suit for the price by the seller. Now, just remember this: suit for the price. Suit for the price means if the buyer has not made the payment, buyer has become the owner, but he has not made the payment, then in that case, seller will become unpaid seller, and now seller can file a suit for the price. So this is what is mentioned here. Why we are discussing this? It's why seller will file a suit for the price. He's asking the buyer to make the payment, but the buyer is not paying him. Therefore, he will go and file suit against him. Why can't he take back the goods? Because now he is not the owner. The ownership has been passed to the other person. So the other medium or the other remedy available for the seller is to file a case, to file a suit on the buyer to recover his money. So whenever there is a case of sale, because in that case of sale, already the ownership passes to the other person, that is the buyer. Buyer becomes the owner. Therefore, if the price is not fully paid by the buyer, then seller has the right to file a suit. This is known as suit for the price. So even if he has been paid, half of the amount, for the remaining half, the seller has the right to file the suit. And this is simply known as suit for the price. This you will again learn in the unit 4. So I think this point is clear. The seller can file a suit for price only when the property has already passed to the buyer. Until then, only damages and not the price itself can be claimed. So if the ownership has been transferred, suit for price can be done by the seller. And if the ownership has not been passed and still there is some kind of damage to the seller, then in that case only damages can be claimed by the seller. So all this detail you will study in detail, in unit 4. Okay. Let's go further. In short, what we want to say here is the exact moment the ownership shifts decides ultimately who will bear the loss, who can file a suit, and who can be sued for price. So if I am purchasing this pen, I am the buyer. Seller has no right now. He is not the owner. I am the owner. So if I lose this pen, maybe after a day or two, if I lose this pen, if this pen gets stolen, I will have to bear the loss. If I have not made the payment for this pen, seller will have the right to file case on the buyer. He will have the right to file the case on me because I have not made the full payment. So if the ownership has been passed, there are various rights which are available to both buyer and seller. And that is why we are discussing this. And the basic thing which we must understand about the risk and reward relationship, the risk basically passes as soon as the ownership is transferred. Because a lot of questions will come: who will bear the loss? What will happen about something which about the goods which have been passed on at a particular point of time? It has been passed on to buyer, and then some mishappening has happened. So that is what we will discuss. Next, two basic factors decide when the property passes. So now we will be discussing in detail how this property passes and at what point of time this property will pass altogether. So passing of property implies passing of ownership. Again and again, these terms are used. Simply you have to understand, if whenever we are saying property has been passed, it simply means ownership has been passed. So if property has been passed to the buyer, the risk in the goods sold is that of the buyer and not that of the seller. I think this point is very, very clear. We have discussed it so many times, though the goods may still be in the seller's possession. So for this point, let me just take you back for the constructive delivery. If you people remember the topic constructive delivery, anyone remembers that? Constructive delivery? Delivery was of 3 types: actual, symbolic, and constructive. You all remember that? Yes. So in constructive delivery, what happens is we have not taken the goods. The buyer has not taken the goods. Yes, warehouse example, exactly, Deepak. So in the warehouse of the seller, the goods are still lying, but they now belong to the buyer. Buyer is the owner of the goods. So if some fire breaks out in that warehouse, and if all those cycles or EV, we were discussing about the electric vehicles. So if all those vehicles get destroyed by the fire, then in that case, who will bear the loss? It will be a loss of the buyer. It is not the seller who will bear the loss. Ultimately, it will be the loss for the buyer. Okay, so that is what we are discussing here. Even though the buyer is not in the possession of the goods, still he will have to bear the loss. He will have to make the full payment to the seller because he had already purchased those goods. So he has to make the payment to the seller, irrespective of the fact that whole of the stock has been destroyed. So that is what is mentioned here. Okay, so let us go further, and now let us start the actual topic section by section, what is contained in this particular unit. Is there anything which you want to understand? Sandeep is saying, but ma'am, how to identify that it's a case of sale or agreement to sell? All things depends on this, like ownership loss. Yes, we will discuss all the examples and you will understand all that, Sandeep. So firstly, in the first chapter, in the first unit itself, you have got the idea what is sale and what is agreement to sell. Normally in sale, what we say that the goods have to be specific. When the goods are existing, it is a case of sale. When the goods are future goods or contingent goods, it is a case of agreement to sell. Okay, so that broad idea you should be having. Yeah, and therefore we will discuss more of these examples so that everything becomes crystal clear for all of you. Okay, so let me just start with the first section, identification of the goods. So section 18, we are starting with the first section of this unit. Section 18, it says that identification of the goods. How you have to identify the goods. So where there is a contract of sale for unascertain goods. So unascertain goods are a type of existing goods only, but they have not been, identified. So unascertain goods, if we are talking about, the property in those goods cannot pass to the buyer unless and until the goods are ascertain. In short, what does it mean? I'm just writing it for you so that you can also note. It simply says that if there is any question about unascertain goods, so if there is any case about unascertain goods, when does the property in unascertain goods passes? When does the property in unascertain goods passes? So it passes when these goods are ascertain. So when these goods are ascertain, when I should write like this, when goods are ascertain, property will pass. Property will pass. In specific goods, then and there the property passes. In specific goods, because the goods are already identified, you have already mutually discussed with each other. I mean, buyer and seller have discussed it with each other. So the property passes then and there. Immediately the property passes. In case of unascertain goods, let us discuss the example of unascertain goods. That cotton bales example which you had. The cotton bales which are lying in the warehouse or in the godown of the seller, he then goes there and picks say 50 bales of cotton and he brings them to the store. At that point of time, what he has done, he has converted unascertain goods into ascertain goods. He has now identified the unascertain goods into ascertain goods. He has identified that, so therefore they are now called ascertain goods. So now when he has ascertained them, now the property will pass to the buyer. Till the point these goods were lying in the godown. At that point of time, who was the owner? Seller was the owner. But as soon as the unascertain goods become ascertain goods, the property will pass to the buyer. That is what is mentioned here. The buyer can get the ownership right on the goods only when the goods are specific and ascertain. Only when he brings the goods to the store or when he ascertains them, then only the property will pass. So this is first thing which you should know. This is contained in section 18. That is it. So if anyone asks you, when does the property in unascertain goods passes? It passes when they are ascertain. It passes when the unascertain goods become ascertain. That is it. That is the only rule which is contained here. Now let us go further to section 19. It talks about intention of the parties. See, this language of law is written in a very tricky way or something very difficult to understand, but it is not as such. It is, if you go word by word, it becomes very easy to understand. So let me just take you with the text, and then we will discuss the examples so that everything becomes clear to you. Okay, what does it say? The property in goods is transferred to the buyer at such time as the parties to the contract intend it to be transferred. If I say that in Hindi, it simply means जब parties की इच्छा होगी तब वो contract में ownership transfer कर देंगे, जब उनकी इच्छा होगी तब वो ownership transfer कर सकते हैं. So as soon as or when they intend to transfer. So it depends on the intention of the parties. When do they intend to transfer? But this section 19 talks about specific goods. It is not talking about uncertain goods. It is talking about specific goods. Specific goods में ownership कब transfer होती है? So in case of specific goods, ownership transfers when the parties intend it to transfer. तो जब हमारी इच्छा होगी तब हम उसको transfer कर देंगे. So how do you determine the intention? How can I say that you people are intending to learn? So it should be visible to me. Either your video is on so that I can make out that yes, this person is intending to study and he is actually studying. So like that, there should be something to understand the intention of the parties. How can you make that out? So intention can be ascertained or intention can be determined from. It is contained in the act only. It is mentioned in the act in this particular section how to determine the intention of the other person. So it says that you can identify what is the intention by reading the terms of the contract. So what is contained in the terms and conditions, you can read that and you can ascertain that. Second is by the conduct or behavior of the parties. How are they talking with each other? What is their behavior? What is their conduct? And the third case is circumstance. In normal circumstance, how does the ownership transfers or at what point of time the ownership passes? So that is the case it is talking about. So intention of parties, basically, it says that the property in goods is transferred to the buyer as and when they intend it to pass. Okay, are we clear till here? It just says that you have to focus on the intention of the parties and how this intention can be checked. Intention can be checked by these three things, by checking these three things: terms of the contract, conduct of the parties, and circumstances of the case. Okay, so let me just tell you further some examples and then we will discuss any of your queries which are there. Okay, let me take one example at this point of time. Suppose I go to a shop to purchase a refrigerator. So there are some models already, dummy models which are there. I can check that. I can take the help of the salesperson, and I can check different models which are lying there. Does the shopkeeper give away the same refrigerator to me if I want to purchase any of that? So does the shopkeeper packs the same refrigerator or he packs some different refrigerator to me? Just tell me. So Dakshita is saying no. Ananya is saying the same is packed. The different one is packed. See, in the showroom, basically, these demo refrigerators are there for people to come and just see them. Okay. But when you are saying that, yes, I want this refrigerator, I want this particular model, this color, I'm okay with this. So you are not taking the delivery then and there. You are giving maybe the money then and there, and the seller will say that I will arrange this refrigerator to be sent to your place. So through some carrier, he will send it to your place. And there is something which is there in their godown. So it is not the same refrigerator which you see there will be given to you, but a freshly packed refrigerator, everything which is there with their godown, they will pack that one. So at that point of time, though you have identified, it may seem that you have identified, but they were uncertain goods. From those uncertain goods, he had identified that and then he has delivered it to you. Okay. Model is same, but they give you a packed one. Correct. Deepak is saying correctly. So a different fresh piece is given to you. It is not the one which is displayed in the showroom, but it is a fresh piece which is lying in their godown. They pack it and then they send it to your home through some carrier. Okay. Now what happens is during this transit, maybe the refrigerator got broken, or maybe there is some or maybe the carrier was at the time when that tempo or anything in which that refrigerator was there, met with an accident and the whole refrigerator was, damaged. So who will bear the loss? The question is this: who will bear the loss? Because you will say seller will bear the loss. Dakshata is saying buyer will bear the loss. Samarth is saying seller will bear the loss. So that is the point. I mean, who will bear the loss? Because you will say the refrigerator has not come to me. I need a different refrigerator. You will call the seller and say to him that I have not received the refrigerator yet. Maybe the seller will say that we have already dispatched it to you. We are not concerned how whether it has reached to you or not. We have already dispatched from our side. So therefore, we need to understand whether the ownership has been transferred or not. And since both of them are not agreeing to it, we have to check what is contained in the law. And therefore, whenever the suit is filed, the judges are also looking to these aspects only which are contained in the law. Are you getting my point? Why we are understanding all this? So since it is a case of maybe unascertain goods, when as soon as they are ascertained, so how they are ascertained again? So no, from Ruchik, these goods are ascertained because from warehouse or from their godown, they have already packed it. They have identified. They have already loaded it on the tempo or any of the carriers. So they have already loaded it, and that has already asked the tempo driver, whosoever was there, he has been given the address to deliver it to the other person, to deliver it to the buyer. So we will read that rule here as soon as the goods are loaded to the carrier, or as we say, the goods, as soon as the goods are shipped. जैसे ही ship में रख दिए जाते हैं goods, अगर हम ship के through transfer कर रहे हैं, otherwise as soon as the goods are loaded into truck or any tempo or anything, ownership passes. From that point of time, whether it reaches to the buyer finally or not, the ownership will pass. So where is it written? We have to read that portion. We have not yet read that, but we will be reading that. Right now, what I am discussing is for the in case of specific goods, how the this ownership passes. So it depends on the intention of the parties. So how to determine the intention? It depends either on the terms of the contract or conduct of the parties or circumstance of the case. But again, it is very difficult to understand because right, there is no direct rule with which we can apply and can understand the intention of the parties. So therefore, section 19 has to be read with some other sections also. So accordingly, we are discussing the next portion. Just allow me to clean the screen first and then we will move on to the next slide. Okay, so there are these four primary rules for passing of the property. So 19.3 tells us that unless a different intention appears. So normally if there is an intention between the parties that they will pass it then and there, or we can identify what their intention is, the rules will go on like that which is mentioned here. Otherwise, there will be some different thing which will be taken up. Okay, so let me just read it for you first and then we will understand it. Section 19 subsection 3 tells us that unless a different intention appears, section 20 to 24 are rules for ascertaining when the property shall pass. So from section 20 till section 24, these are very, very important sections. This will help you in understanding when the property is actually passing from one person to another person. Right now, we have studied section 18. It was talking about unascertain goods. It simply said that if you want to pass on the property of unascertain goods, it has to be first converted into a certain goods. That is the first point, and that was the only thing which was mentioned in section 18. Section 19 talks about the intention of the parties. So in case of specific goods, it is the intention of the parties which matter. If they intend to transfer it then and there, the goods will pass. If they intend to pass it later on, the goods will pass later on. But how to determine that, how to understand that? So the details are contained in section 20, 21, 22, 23, and so on. Okay, so we have to study those sections. So let me just take you through these sections. Let me first cover the topic and then we will take up the questions if you have any. Okay, so section 19 and section 20, 21, 22, they talk about specific and uncertain. Specific and ascertain goods. So property passes when intended to pass. The act then breaks it into 3 stages depending on whether the goods are in deliverable state or not. Okay, so here at this point of time, I should again write something so that it becomes easier for all of you to understand. Okay, so section 19 talks about intention. Okay, then we have to study section 20, section 21, and section 22. These are the 3 sections. These talk about specific goods. I'm just writing these talk about specific goods. When the goods are specific, okay, what happens if the goods are specific? Then it is specifically mentioned in section 20. Section 20, it is applicable when the goods are in deliverable state. Deliverable state. Okay. Section 21 is applicable where the goods are to be put into deliverable state. I'm writing it in short, deliverable state. I hope you remember what is deliverable state. Otherwise, we will discuss that also. Just give me 1 minute. And the third one, it is talking about the goods are in deliverable state, but price is to be ascertained. Price to be ascertained. What is meant by this? Let us just discuss this and then we will proceed. Okay. So are we till here? Section 19 just talks about the intention. It simply says that as and when the parties intend, the property will pass. But again, until and unless some different intention appears, we have to apply this sections, section 20, 21 or 22. So if it is a case of specific goods, just don't see here and there, directly check this section. Either it will be a case of section 20 or it will be a case of section 21 or it will be a case of section 22. That is it. Okay, so if it is a case of specific goods, you have to identify whether it belongs to section 20, 21 or 22. Now let us understand what is the difference between the 3. Section 20 says the goods are specific and are also in a deliverable state. What do you mean by deliverable state? Does anyone remember there was a definition of deliverable state in unit 1? In unit 1, there was a specific definition with respect to deliverable state. Section 2, clause 3. Section 2, clause 3, there was this definition of deliverable state. When the goods are, available in the deliverable state, it simply means that they are ready to be delivered. Suppose I have to take this mobile. I'm again and again taking the example of mobile because that is very handy for me. So if I have to take the delivery of mobile, I have chosen the mobile because this is a specific goods. I have selected it from the shop and the shopkeeper has given me then and there. He has just packed it because it has a box and whatever instruction manual is there, and if there are some earplugs also with that, and the charger is also there. So everything is packed in a box, and then the box is ready for me to get it delivered for myself. So basically, as soon as the box is ready, we can say that mobile is in deliverable state. Okay, let us take one more example. When we go to a bakery shop and you select some pastries, so you ask the shopkeeper to give you selected pastries, any black forest or any chocolate pastry, whatever you like. So you have identified. What does the shopkeeper do? He will ask you whether you want it then and there or you want to have it at home so that he can pack it. So if you tell him that I want to eat it at home, so please pack this. So he will pack it in a box. So as soon as he packs that in a box, the goods are ready to be delivered. And it is the duty of the buyer to take the delivery because ownership has been passed. As soon as the pastries have been put into the box, it simply means, because it is there in the law, that as soon as the goods have been delivered or they are in a deliverable state, at that point itself the ownership passes. So as soon as the pastries have been put into the box or in a poly bag or whatever case maybe, so that is in a deliverable state. Even if you are not taking the packet then and there, you might be saying that you can keep it. I'll just finish off my class because my coaching center is here only. I will finish off my class and then I will take this packet and I'll go. So if you are still asking the shopkeeper to keep the goods with him, that is a kind of constructive delivery. You have not taken the delivery then and there. You are still asking him to keep those goods for him for a while because you have a 1 hour lecture to attend, and then you can come and you might be taking that. Otherwise, if you take that right away, your other friends will eat that pastry and you will not be able to eat that. So that is your intention basically. So what happens is when the goods are in deliverable state, the ownership has already been passed. So if at any point of time a fire breaks out, or these pastries get damaged or destroyed by any case, by any of the reasons, in that case it will be a loss of the buyer because buyer has become the owner. That is the only thing which you have to learn here. So in this case, if we talk about, in case of deliverable state, the ownership will pass to whom? It will pass to the buyer. So I'm not writing it because in all these cases, the thing is the same. If we have to now understand what is the difference between these three sections, what is contained in these three different sections. So all of these three sections, 20, 21, and 22, they talk about specific goods. But section 20 clearly talks about goods which are in deliverable state. So seller has already done his part. The goods are ready to be delivered, and the buyer can take the delivery then and there, or maybe if he wants, he can take the delivery later. That is up to him. But ownership has already been passed. So the ownership is with seller. Oh, buyer, sorry. Ownership passes to buyer. That is what is clearly mentioned here. That is the first thing. Now let us talk about section 21. What does this section 21 says? The goods are specific, but they are still to be put into the deliverable state. So something has to be done and then it will be put into the deliverable state. So suppose we go to the bakery shop and then we ask the shopkeeper or the baker that please write something on this. Or maybe we need some special kind of decoration on that cake which is there. So proper decoration has to be there. Some, we have to get some name of, written over it. So if you are asking something to be done and then it will be put into the deliverable state, that point of time or at that particular thing, section 21 shall be applicable. So what is written here is when the ownership will pass. So ownership will pass. Ownership will pass. Can anyone tell me when the ownership will pass? When the ownership will pass, it is very easy. If you can just understand this fact, the ownership will pass here. It will allow me to write or not? It will not allow me to write. Okay, let it be. So ownership will pass in this case. Ownership will pass in this case as soon as the goods have been put into deliverable state. So as soon as the goods are put into deliverable state, the ownership will pass. This is contained in section 21. And when we talk about this section 22, it says that goods are in deliverable state, but the price is yet to be ascertained. If you remember, price either is determined by the mutual agreement or discussion between the buyer and seller, or by some valuer also you can get the price fixed. So section 10, wherever some section 10 is applicable, then that is a case of this section 22. So here what is mentioned, that goods are there in the deliverable state, but the price is yet to be ascertained. Price is yet to be ascertained by maybe weighing or measuring the goods. Then in that case, as soon as that part is done, I mean, when the goods are weighed or measured, or when the actual price is determined, at that point of time, the ownership will pass. So that is the distinction between these three. Are you able to understand? Because we will be discussing again in detail in the coming slide, but for the time being, since the topic was there, so I thought to just write it for you. Is it clear? Somewhat it is clear that why these three sections are there. All these three talk about specific goods. Section 20 talks about specific goods. 22, okay, we will discuss in detail. Don't worry, Deepa. Rest all, I think Just the point is, if the goods are ready to be delivered, then and there the ownership will pass. If they are yet to be converted into deliverable state, then they will be converted, only then the ownership will pass. Okay, and the buyer should also be informed about that, that now the goods are ready in delivered form. Okay, they are in the deliverable state now. And the section 22, it talked about uh, the goods are in deliverable state, but some weighing or measurement has to be done to ascertain the price. So when the price will be ascertained and the buyer shall be informed, at that point of time, the ownership will pass. So that is contained in section 22. So this is what is discussed in these sections. That is, in short, we are discussing here. I'll be taking all these points again and again so that in detail you will understand. Next is section 23, unascertain goods. So in case of unascertain goods, I think we should take the theory part first and then I will come to section 23. Let us discuss this section 21, 22 and then we will take up the next section. It will be better if we go that way. Just a Okay, so let us discuss section 20 when the specific goods are in deliverable state. So the rule is, when there is an unconditional contract, that means there is no condition with respect to packing, there is no condition with respect to you know do any kind of working over the goods, do any kind of labor over the goods. So if the contract is unconditional, so whatever goods are there, as it is, you are taking those goods. So when there is an unconditional contract for sale of specific goods in a deliverable state, so goods are already ready to be delivered. So if goods are ready to be delivered, or if goods are in a deliverable state, the property in the goods passes to the buyer, then the contract is made. As soon as the contract is made, the ownership will pass. So that is written here. As soon as the contract is made, so immediately the ownership will pass. This next line is very important and it is immaterial. So it is of no use. It is immaterial whether the time of payment of the price or the time of delivery of the goods is postponed. So whether you are making the payment then and there or you are deferring the payment, it hardly matters. Whether delivery is done then and there or delivery is deferred, it hardly matters. So if the goods are ready to be delivered, ownership will pass immediately, irrespective of the fact that the payment has been made or not, or whether the delivery has been made or not. Is this point clear? Is this point clear? Yes, no? Yes? Okay, Jyoti has understood, Ushri has understood, Akshit has understood, Vishnu has also understood. Okay, I'm not taking all the names. Finally, what is the condition here? We must understand goods must be ready for delivery. It is written at the end, goods must be ready for delivery. So deliverable state means goods are ready to be delivered. So nothing more is to be done on them. Everything is already done on those goods. These are ready to be delivered. Nothing more is to be done on those specific or identified goods. Okay. So there is an example also. X goes into the shop and buys a television and asks the shopkeeper for its home delivery. The shopkeeper agrees to it. The television immediately becomes the property of X. The contract is unconditional. The TV is specific and ready for delivery. The postponed delivery does not matter. So if that TV itself is, given to him, in that case, it is a case of this deliverable state and section 20 shall be applicable. Okay, so this was the uh, decision here in this particular case, that immediately the ownership will pass, even though the delivery was to be done maybe next day or some other time. So it hardly matters when the delivery is done. So what you have to check whenever there is a question in your exam, firstly you have to check whether these goods are specific goods. Then you have to check whether these goods are in deliverable form or not. So if it is a case of specific goods, if they are in deliverable form, don't be bothered about payment or the delivery, because both of these things are irrelevant. Whenever the delivery is done, that is not of any concern to us. Whenever the payment is done, that is also not a concern for us, because when suppose we purchase television or refrigerator or mobile, we can also purchase it on installments these days. No? So payment can be deferred, but still the ownership will pass on. So that is very, very important. So the trigger word for us to understand is deliverable state. Postponement of payment or delivery is irrelevant. So whether the payment is done today or maybe next day or some other time, it hardly matters. When the delivery is done, that is also not relevant. If the goods are ready to be delivered, that means ownership has been passed. That is the only rule which you have to understand. Okay, so that was very simple, I guess. Next is section 21. Okay, just be focused. You will understand each and everything. We will do lots of examples. So everything will be clear to you by the end of the topic. Next is specific goods to be put into a deliverable state. Okay, let me read it slowly for you. Specific goods to be put into. To be put into means what? They are not in deliverable state. Okay, they are not in deliverable state, but they are to be put into. To be put into means what? To be put into, something is to be worked upon those goods. Something is to be done on those goods to convert it into a deliverable state. Maybe some packing is to be done. Maybe sometimes it happens na, that we purchase car, but car is not delivered then and there. When we choose any car, it is not delivered then and there because some screws and bolts are to be, tightened, or some fittings are to be done so that you can use it in a good way. So to be put in a deliverable state, that is the condition which is mentioned here. So this section 21 is applicable only and only to those situations where there is a case of specific goods, but the goods are not ready to be delivered. They will be converted into that position. They will be converted into that state at some later point of time. Okay. And that may take, 5 minutes, 10 minutes, or maybe an hour or a day. That is something else. So specific goods, in case of specific goods, as and when they are put into deliverable state, to be put into deliverable state, in that case, this section shall be applicable. Okay. So let me read the theory part for you first, and then we will understand the rest of it. So the rule is, when there is a contract for sale of specific goods and the seller is bound to do something. So you have asked seller to do something on those goods. So either you have asked him for a different kind of packing, or maybe some rework is required on those goods. Sometimes we purchase, a pant or shirt from a shop, and then we ask them to do some, fittings on that, if that is possible on their shop. So after that point of time, when they become ready or according to our fitting, then only that will be considered as in a deliverable state. Okay. So when there is a contract for sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into the deliverable state, the property does not pass until. So property kab pass on hogi? Property will pass on only when that thing is done and the buyer has the notice of it. So when the shopkeeper has done that packing, whatever you have asked, so he has packed the goods the way you have told him, and he has also informed the buyer, because telling the buyer, informing the buyer is also important. So buyer has the notice of it means buyer has been informed. He has been informed that yes, this has been done. So as soon as he has been informed, it is assumed that the ownership is passed, because we have already told him. Now it is up to him to take the delivery. We have already set the goods. The seller will say that I have already prepared the goods. I have brought them into the deliverable state now. No further instructions are there for me. I have already informed the buyer to take the delivery. He has not told me whether he will come himself or I have to deliver. So my part is done. So seller will say, I have already transferred the ownership to buyer in this particular case. So that is the case which is mentioned here. So let us see the example which is given. Peter buys a laptop from an electronics store and asks for a home delivery. The shopkeeper agrees. However, the laptop does not have Windows operating system installed. The shopkeeper promises to install it and call Peter before making the delivery. So why does he call? So basically to tell him that we have installed this Windows system, and now I have given this to some courier company or maybe some carrier. So through this you will get you will get this laptop at your home directly. So since he has already brought the thing into the deliverable state and as per the instructions of the buyer, and also he has informed, the shopkeeper has informed the buyer, therefore the property transfers to Peter only after the shopkeeper has installed the operating system and this making the laptop ready for delivery and intimated to the buyer about this. So if he has only installed the software and he has not informed the buyer, then in that case half thing is done. So since buyer is not aware, he will not take the ownership, or he will not be presumed to have the ownership. So it is very important for the seller to tell the buyer that he has done his part. Now the goods are ready to be delivered. You can take the delivery of your own, or let me know if I have to deliver it to your place. I will do that. Maybe he will charge something for that, but that is between them. How do they decide? Okay, but this information, transferring of information is very important. Communication has to be there. Okay, so both are necessary. The act required to put the goods in deliverable state must be actually done by the seller, and the buyer must be informed. Both the things have to be done, and only then the ownership will be passed. Are you getting this point? Any doubt in this particular slide? Section 21, are we okay? If the seller does not install OS window, in that case, the thing, why will we accept? Being a buyer, why will I accept this laptop? Okay, or I will ask the buyer, I will ask the seller to get that done from wherever he wants. If he wants some extra charges for that, maybe that is up to me whether I'll be paying that or not. So it is decided between buyer and seller. That was the condition, that I will take the laptop only when this Windows is installed into it. So what is Sandeep saying? Ma'am, both conditions are fulfilled, is compulsory. If one part of both is complete, then yes, yes. So in nutshell, you have already mentioned that both the things have to be completed. Okay, okay. So let us go further. Are you all ready? Section 22. Should we go on it? I need some yes, yes, yes. Okay, great, great. So I like the energy. Just be energetic. You will learn each and everything. Don't worry. Section 22. So what was it about again? It was about the specific goods. It was about the specific goods. Let me just highlight that portion again for you. It is related to the specific goods. Again, they are in deliverable state, but what is the condition? Price is not ascertained. Price is still to be ascertained. Seller must do something by which the price can be ascertained. So again, if the price is not decided, how can one purchase the goods? So therefore, the ownership is still with the seller. As soon as he determines the price, as soon as he ascertains the price, the ownership will pass to the other person. But again, he must inform the buyer that he has done his part. So again, here also you will see two kind of conditions. So let me just read the theory part for you first of all, and then we will read the example, and then we will finalize, or we will conclude whatever we have discussed. So what is the rule? There is a contract for sale of specific goods in a deliverable state. So complete thing. Specific goods भी होने चाहिए, deliverable state में भी होने चाहिए, but the seller is bound to. But what is the duty of the seller? Seller is bound to either weigh. Weigh means he has to do the weighing and measuring of the goods. He has to conduct some test maybe, or to do some act with reference to the goods for the purpose of ascertaining price. Price determine करने के लिए किसी भी तरीके से अगर उसको वे मेजर कुछ करना पड़ेगा, तो सेलर जब तक वो नहीं करेगा तब तक गुड्स का ओनरशिप पास ऑन नहीं होगा. So until and unless he weighs, measures or tests, or maybe he involves some other party to do that, till that point of time the ownership will not pass. So it is written here, the ownership does not pass until such act or thing is done. What is that act or thing? Weighing, measuring, testing, anything for the purpose of determining the price of the goods. And the other condition which is mentioned here, because both these conditions have to be satisfied. Seller ने अपना काम कर दिया, but उसने buyer को inform नहीं किया, तब तक कुछ नहीं होगा. So seller must have done his act, as well as he has informed the buyer. Buyer has the notice of it. That simply means seller has informed him that yes, now the price is ascertained, and at that point of time the ownership shall pass on. Okay, so let us read this example. A sold carpets to the company which were required to be laid. What do you mean by required to be laid? The carpet, it is not just that the seller will deliver the carpet to me. He will send any of his persons to lay it down on my floor by preparing some, because there is a proper process how to lay down the big carpets, how it is to be done. Whole of the furniture will be taken out, the floor will have to be cleaned, cleared, and then maybe some nailing has to be done because that carpet should not move here and there later on. So maybe some sticking or some any other thing has to be done. So proper laying is also required. So carpet has to be laid at our place. That is the condition which we have told to the seller. The carpet was delivered by the company's premises, but was stolen before it could be laid. So it was not in a deliverable state. Here, the example is obviously some different example has been taken here. We are now here discussing what is not in deliverable state. So if the goods are not in deliverable state, obviously it will not come into this, and the who will be the owner? Buyer will obviously not be the owner because the goods are not in a deliverable state. Seller will be the owner and he will bear the loss. So that is what is contained here. It was held that the carpet was not in a deliverable state as it was not laid, which was a part of the contract, and hence the property had not passed to the buyer. Okay, so that is the thing which is mentioned here. But here, this example is related to something which is for a deliverable state. So if you want to understand what is deliverable state and not a deliverable state, then this example was suited here. With respect to the ascertaining of price, there will be a different example which I'll be taking verbally. So let us assume that example. If you remember, at the time of doing the first unit, uh, for section 10, for the valuation purpose, we had taken one example. Never mind, we will take that. So if there are some gold bangles, if the seller wants to sell the gold bangles, he has to first, weigh or measure them, because the weight of gold depends on how much is the weight of the gold. Okay, so whatever the bangles are, they have to be first weighed, how much gold is there in that particular bangle, and accordingly, it has to be multiplied with the current rate of the gold. So as soon as he weighs or measures and then he determines the price, at that point of time, the ownership will pass. Until and unless he does that measurement, the ownership will not pass. Okay, so that is the thing which is given here. So that is, I mean, this section should be clear now to you that the goods are specific, the goods are in deliverable state, but the price is not ascertained or the price is not determined. In that case, the ownership will pass only on the condition, then the price will be ascertained and it will be informed to the buyer. Is this section clear? Are we clear till 22? Pragati, in this case, obviously, yes, the seller will bear the loss. Yes, you are right. Valuation is an example for it. Yes, Deepak, you are very much right. In case of valuation, properly this section will go. But here actually it says that if seller can himself weigh and measure, that is also okay. And if he's taking help of some other person, if he's taking help of some other person, in that case, section 10 or valuation shall apply. Okay. It may happen that he himself can do that. Are we okay to go for the next section, section 23? So for specific goods, we have three sections, section 20, 21, and 22. Now we are going for unascertain goods. Are we all ready for unascertain goods? Okay, Vishnu is asking something. In case of section 20, if the goods are destroyed in the delivery, the loss lies on buyer, correct? Because if they are ready to be delivered, the property has already been passed. Now seller will not be liable for these losses, buyer will be liable. So even though buyer could not use those goods, even though he had made the payment, but he could not use those goods because they have been destroyed in the transit only, still he will bear the loss. It's his loss. Okay, only Ananya is saying that she is ready to take up the next section. What about the others? Are we all ready to go for section 23? Akshat, I'll take your doubt at the end. If you are okay to go for section 23, we can take that now. Okay. Samarth is asking, ma'am, if he hasn't paid. So payment is not a matter here, no? Payment can be deferred. It was mentioned that the postponement of payment is immaterial. Whether you have paid or not, it is immaterial. Seller will file a suit obviously to recover the prices if you have not made the payment, because buyer will say, I have not received the goods, why should I make the payment? And seller will say, I have already given the goods, so I should be paid. So for that reason, court cases will be done, and he will file a suit for the price. And because of this section particularly, seller will be at advantage. He will get the money. So that is how the cases are decided in the court. Okay, so let us go for section 23. We will study 2-3 slides more. There will be some questions and then we will take a break. Okay, no break before that. So section 23, subsection 1, it is with respect to unascertain goods. So one rule we have studied about unascertain good is that the property will pass only when the unascertain goods are ascertained. When unascertain goods are ascertained, only then the property will pass. Okay, so what is there in this particular section? Section 23(1) again talks about the sale of unascertain goods, and it says that the goods have to be ascertained as well as they have to be appropriated. So one more term has been added here. The goods have to be ascertained as well as they have to be appropriated. They should be appropriation means what? You might have all learned about P&L appropriation account. So what is that P&L appropriation account? Anyone has any idea? P&L appropriation account, I'm asking accounts question. Below the line items, it is distribution of the profit. So whatever profit is there, it will be appropriated in different heads, maybe for dividend distribution or transferring into reserves or any other aspect, right? So likewise, whatever goods you have ascertained. So first of all, if the goods are unascertain, you have to ascertain them. That means you have to identify them, and then you have to allocate them. Then you have to allocate means you have to appropriate them so that they will be used by the buyer for his own purpose. So that is, these are the new words which will be coming here in this section 23, but don't get confused by them. It is just that you have to mention it specifically whenever this question of section 23 comes. So in case of unascertain goods, property will pass when the goods are ascertained and appropriated also. So both the words have to be there. So let me read it for you. Section selection of goods with the intention of using them in the performance of the contract and with the mutual consent of the seller and buyer. This is meant by appropriation. So what is the actual meaning of or what is the actual definition of appropriation? Let me read it again for you. Selecting the goods. So when you are selecting the goods, who is selecting? Maybe seller is selecting the goods and he is asking the buyer, are these okay? So either seller is selecting and then he's asking the consent of the buyer, or maybe the buyer is selecting the goods and he's asking the consent of the seller. Anyway, in any of the way, it is a mutual consent, or by mutual consent, both of them are agreeing for that particular thing. So in that way, when they have agreed to particular set of goods that yes, we are okay with this particular goods, whatever is being identified, and these are the goods which we will be using in our contract. Contract means it will be the subject matter of our contract ultimately. Therefore, these are known as appropriation. This is simply known as this activity which we have done, selection of goods. Okay, appropriation is just the activity which is done by the buyer or seller. How it is done? So I have chosen the suppose let us take the example of those cotton bales again. So cotton bales are lying in the godown of the seller. If seller himself goes there, he selects those cotton bales, whatever cotton bales are lying there, he has identified some and he has brought to the store, and the buyer is okay, whatever you have brought, it is fine to me. Then it is like seller has appropriated and then he's asking the buyer to confirm. And if both are okay, ownership will pass. Okay, but sometimes it happens that, let me take one example. Maybe you have done that or not. When we go and purchase fruits or vegetables, sometimes we ask the person who is selling the vegetables or fruits to make the selection for us. So he has identified that this mango is good. So he has, selected from his side 1 kg of mango. But out of the selection, we are not okay with one or two mango. So we remove that and we replace with some other mangoes. And the seller is okay. Okay, whatever you have selected is fine. So that is known as, appropriation. So appropriation is basically when seller has identified the goods and he has obtained the consent of the buyer, or the other way, the buyer has selected the goods and obtained the consent of the seller, or mutually they have decided that this is to be done like this is known as appropriation. Are we okay till here? Appropriation. Akshat, move on. Next example is there. You are stuck on the earlier thing. Okay, so it is just that selecting the goods. So appropriation simply means selecting the goods. Who is selecting, how it is done, that is what is mentioned here. It should be done with the consent of each other. It should not be forceful act that whatever seller has selected, you are forced to purchase that. It is not like that. You have to give your consent that yes, it is okay. I am ready to buy that. That is why it is known as goods have to be ascertained and appropriated. Okay. So what are the 7 essentials for this 23 section and what does it say? It simply says that there is a contract for sale of unascertain goods, because this section is applicable, or what we are studying right now is when this section will be applicable. So this section is applicable when these are the circumstances. First point is when there is a contract of unascertained or future goods. Second, the goods should conform to the description or quality stated in the contract. So we have already understood description. If the seller has described the goods should match accordingly to the description. Or if he has stated that goods will be of this quality, obviously the goods have to be of that quality. So goods should conform with the description and quality. Third is goods must be in a deliverable state. Fourth, the goods must be unconditionally appropriated. Now, again, this word is important for all of us. The goods are not only appropriated, but they are unconditionally appropriated. What is unconditional appropriation? No further act is to be done. Whatever has been appropriated is good. No further instructions are there. So it is unconditional without any further conditions. So goods must be unconditionally appropriated to the contract by delivery to the buyer, his agent, or to the carrier, as distinguished from a mere intention to appropriate. So, okay, let me just break it down for you or simplify it for you to understand. Seller is actually having the intention to sell. It is not just that he's, doing it for the sake of doing. He's actually intending, or he's actually selecting with the intention to sell. Whatever the goods he has identified, whatever the goods he has ascertained or appropriated, he will now deliver it to the buyer or his agent or to the carrier. So that is what is clearly mentioned here. Intention should be to appropriate. There has to be an intention to appropriate, and it should be distinguished from mere intention to appropriate. That means he actually wants to deliver it to the other person, and it is not just that he's doing for the sake of just selecting. He actually wants to deliver it. He actually wants to transfer the ownership. The appropriation may be made by the seller with the assent of buyer, or buyer with the assent of seller. So how this appropriation or selection is done? So in short, what I can write is appropriation means selection of the goods. Okay. So when does the ownership of unascertain goods pass? Ownership of unascertain goods passes when the goods become ascertain and they are appropriated. A plus A. 2 A's are required. So first is they have to be ascertained and then they have to be appropriated. Now how appropriation is done? Appropriation means selection. So who selects? Either the buyer will select and he will get it confirmed from the seller, or the seller will select and he will get it consented or assented from the buyer. So it is that way. So appropriation must be there. That is what is meant here. Next, the assent, the consent may be expressed or implied, because it is not that every time we will, loudly say yes or no, or we will write it somewhere that yes, I'm okay with this selection. So even your body language or by your implied conduct or behavior also, you can signify that you have given the assent. Okay. Next, the assent may be given either before or after the appropriation. At any point of time, this assent can be given. So if all these points are there, or otherwise we can say, if you have to follow this section 23, all these points have to be there. Then only this section 23 will be applicable. So in short, what does this section 23 tells us? First of all, in case of uncertain goods, how the ownership or when the ownership will be transferred. The ownership will be transferred when the goods are ascertained and they are appropriated. What do you mean by appropriated? Appropriated means selection of the goods. How this selection is made? Selection is done either by buyer with the consent of the seller or by seller with the consent of the buyer. So this is the whole thing which is mentioned, and as soon as the goods are ascertained and appropriated, the ownership will pass to whom? The ownership will pass to buyer. Before that, who is the owner of the goods? Seller is the owner of the goods. And as soon as this ascertainment and appropriation is done, it is that the buyer will be the owner. And again, one more thing you should remember here, the ascertainment or the appropriation which is done, it is unconditional appropriation. Somewhere it was written, no, unconditional appropriation. No further conditions are there. It is unconditional appropriation. Are we okay till here? Are we okay till here? Yes, no? Okay, great. Akshar will take up all your doubts at the end, don't worry. Okay, let me move further to next. Again, we have, so this was 23 subsection 1. Now there is a twist in this, or there is some further, point which need to be discussed here. Section 23.2. I think this I have already told you earlier. Let me see how many of you remember. Delivery of goods to the carrier. When the seller delivers the good to the carrier, who will be the owner of the goods? Or then whether who has the property in the goods, or how can we say that? Sorry. As soon as the goods are delivered to the carrier, who will be the owner of the goods? Deepak is saying buyer is the owner of the goods. Samarth, Dakshata, Bhumik, everyone is saying buyer is the owner. Why buyer is the owner? Do you know the reason now? Section 23.2 you have to apply directly. Section 23.2, because we are talking about unascertain goods basically. So in case of unascertain goods, then they are ascertained and they are put to the carrier. Okay, as soon as they are put to the carrier, the seller has selected the goods and he has loaded in the bus or truck or tempo, whatever it is, or maybe ship or plane, whatever, that is all considered in carrier only. So as soon as the goods are loaded, ownership is transferred. If any accident takes place, if anything else, any destruction happens, then it is the loss of the buyer. So that is what is mentioned in 23.2. So this 23.2 is important for this purpose only, because it specifically talks about the case or about the situation when delivery of goods is made to the carrier. And obviously section 23 is pertaining to unascertain goods. So whenever unascertain goods are ascertained and appropriated to the carrier, because selection is done by the seller and then he is putting it into the carrier. There might be some cases where the seller is not getting the opportunity to discuss with the buyer. At that time also, ownership will transfer. That is the case which is mentioned here. So let us discuss the rule. Where in pursuance of the contract, the seller delivers the goods to the buyer or to a carrier or to other bailee. Bailee here means any of the agents of the buyer maybe, whether named by the buyer or not, for the purpose of transmission to the buyer, and does not reserve the right of disposal. There are lots of conditions, Just I'm highlighting this point. Just leave this point for the time being and rest. I think every point you understand. He is deemed to have. He is deemed means मान लिया जाएगा. Deemed कहीं भी आ जाता है law में तो मान लिया जाएगा. Though it does not look like, but it will be assumed. It will be deemed that unconditional appropriation has happened. Why it is said that मान लिया जाएगा या deemed a provision? Why it is mentioned as deemed provision? Because normally appropriation has to happen with the consent of both the parties. Buyer has to ask seller, seller has to ask buyer. But in this particular case, it might happen that seller has identified on his own. He had not discussed it with the buyer. He has just loaded the goods on the carrier. So even if he has loaded the goods on the carrier, it will be assumed, it will be deemed to be unconditionally appropriated. That means the ownership will pass on to the next person. So this is what is mentioned here. And if we talk about this particular point, does not reserve a right of disposal. So this point I will take section 25 first and then I will explain it to you. Okay, so this point will be clear when we will discuss section 25, because section 25 specifically talks of the situation when the right of disposal is reserved. So let us not get into that. Let us read whatever example is there. A bill of lading of a railway parcel is made out in the name of buyer and is sent to him. Ownership in the goods passes from seller to the buyer. If the goods are subject to accidental loss or theft, the seller will not be liable. I think this example is clear. Then there is one more example. M places an order for a book with a bookseller in Mumbai and asks him to send it by courier. Payment to be done by check. The seller sends the book by courier. The book is lost in the way. The seller wants the buyer to bear the loss. So because of this particular section, it is a case of unconditional appropriation, and here buyer M has become the owner of the goods and therefore he must bear the risk of the loss. Okay, so that is the situation here. Are we okay till this 23(2) subsection? Sandeep, this right of disposal, I will just tell you in section 25. Let me first explain section 25 and then I will come back to this particular point. Okay, otherwise confused. Okay, so let us first answer some questions and then you can take a small break of 5 minutes and then we will come back and understand section 25. Okay, this is the first question for all of you. Let us quickly check who has got the right answer for this. Property in uncertain goods passes when the goods are actually ascertained. Correct. And if there was an option of ascertained and appropriated, that would have been a better option. Okay. Next, risk prima facie passes with dash. So prima facie, wherever you find this term, it basically means primarily. So risk normally, or primarily passes with what? It passes with the ownership. Whosoever is owner will bear the risk, will bear the loss. Correct. B option is correct. Most of you have given the correct answer. Specific goods in deliverable state passes when. So do you remember the section? Specific goods and they are in deliverable state. Specific goods in deliverable state. So Dakshita has mentioned the section correct. Section 20. Option is B. Or option is any other option? Akshit is also mentioned correct. Correct. When the contract is made, then and there it is passed. Correct. Because delivery is not important. Whether the goods have been delivered or not is immaterial. Price has been paid or not, it is immaterial. Okay, so that the contract made, that option was correct. Appropriation means what? Appropriation means what? And this is read in which section? Selection of goods for the contract. Correct. Everyone is correct. Bhumek, you are right. It is section 23. 23(1). Correct. 23(1), 23(2) both. Okay. Appropriation. So appropriation has to be done conditionally or unconditionally? Tell me. According to section 23, it is conditional appropriation or unconditional appropriation? Unconditional. Without any condition, appropriation has been done. Very correct. Very good. Great energy today. Very nice. Question number 5. Delivery to carrier generally amounts to. Delivery to carrier generally amounts to. Option C, unconditional appropriation. And can you exactly write which section it is? Which section it is? 23.2. Correct. Vishnu, Dakshita, Samarth, every one of you have got that right. Now you can take a small break. Or I also have a descriptive question. Let us take this descriptive question and then we can have a break. Okay, so let us quickly see this. Mr. S agreed to purchase 100 bales of cotton from B out of his large stock and sent his men to take the delivery of the goods. So who is buyer, who is seller, and what are the goods? Mr. S agreed to purchase, so Mr. X is buyer from B. So B is seller and the bales of cotton, these are the goods. Okay. They could pack only 60 bales. Later on, there was an accidental fire and the entire stock was destroyed, including those 60 bales that were already packed. Referring to the provisions of the Sale of Goods Act 1930, explain as to who will bear the loss and who and to what extent the loss shall be borne. So basically, he wanted 100 bales of cotton, but only 60 bales were identified, not the entire lot. And meanwhile, the fire broke out. So who will bear the loss? Let me quickly read the answer. Anyone has the answer? So how many sections are referred here? See, section 26, because risk passes with the ownership. We have started with that. Then we have to read section 18, read with section 23, because it is talking about unascertain goods. Unascertain goods, firstly, it is mentioned in section 18 that you have to ascertain them. Then in section 23, it is again mentioned you have to ascertain and appropriate them to pass on the property. So therefore, all these sections are referred. Okay. So ultimately, applying all this, if I read it from here, applying the aforesaid law to the facts of the case. Second last para I'm reading. It is clear that Mr. S has right to select the goods out of the bulk, and he has sent his men for the same purpose. So because we know that selection has to be done either by the buyer with the consent of the seller or seller with the consent of the buyer. Hence, the problem can be answered based on the following two assumptions and the answer will vary accordingly. So the first option they have taken. So sometimes it happens that you might also have two different answers in your mind. So you can write it this way, where the bales have been selected with the consent of buyer's representatives. In this case, the property in the 60 bales has been transferred to the buyer and the goods have been appropriated to the contract. Thus, the loss arising due to fire in case of 60 bales would be borne by Mr. S. As regards to another 40 bales, the loss would be borne by Mr. B, who is the seller, since the goods have not been identified and appropriated. Now, let us discuss case number 2, where the bales have not been selected with the consent of the buyer's representative. In this case, the property in the goods has not been transferred at all. Hence, the loss, whole of the loss will be borne by Mr. V completely. Are we okay till this point? There is one more question, but I think you can take a break now. You can take a break now and we will be back by 3:35. 23, one slide I can show. Pause, Vishnu, just a second. Yeah, are we all back? Can we start the session? Okay, great, great, great. I'm just moving my slides wherever we were. Okay, now we have to discuss this. Goods sent on approval, or I should take up this section 25 first, so that that part will be clear. So let us take the section 25. Section 25 talks about seller's reservation of the right of disposal. Can you just read it slowly again for yourself? Seller has a right. What kind of right is there with the seller? He can reserve the right of disposal. Right of disposal, if I take this like this, just let me firstly underline it for you so that it is easily understood. Let's start from here. What do you mean by right of disposal? Right of disposal means selling rights. Basically, right of disposal means selling rights. So seller has reserved that. Whenever you do reservation, what does that reservation means? How many of you do the bookings for any movie show? You reserve the seats earlier, or whenever you go to a restaurant or something, you reserve the seats. So reserve means what? To book it for yourself. No one else can take that place. So it is specifically for you. So seller has, yes, in train also you do the reservation, Sandeep, correct. So what does that mean? Deepak is doing in train again. Okay. And bus also, of course. And in plane also you can do that. Okay. Let us move further. Let us go to the topic. It is meant that seller is reserving, seller is holding his right so that no one else can take that. What right he is holding? He is holding his right of selling the goods or selling the ownership rights. So even though the goods have passed, even though the payment has been made, he's saying that I will not give away my selling rights. So sometimes seller has this kind of reservation. He puts some conditions that if this condition is fulfilled, only then I will pass on the selling rights. Until then, I will not pass on the selling rights. So if that kind of thing is existing, this is discussed in section 25. So section 25 talks about the situation when seller has a reservation on on the disposal rights, on the rights to dispose. Finally, the selling rights, even though the goods have been given, maybe you cannot sell it further, maybe you cannot use it. So that kind of reservation is levied by the seller. So let us discuss that why and what is the use of this kind of reservation. Why will he apply this kind of reservation? See, sometimes what happens is the buyer takes away the goods. He may say that I will pay you the money maybe tomorrow or a week later or something like that. And the seller gives away the goods. So it might happen that the buyer never pays the amount. So in that case, just to safeguard himself, he has this kind of right so that the buyer does not further transfer the goods to anyone else before paying the full amount to the seller. Okay. Yeah, it is because of that price only. Everything, the seller is concerned about the price. If full price is paid to him, he will obviously give the selling rights. He cannot hold the selling rights after the payment of price. If he is doing that way, suit can be filed against him. Okay, so let us read this. The seller may, so it is written, he has a choice. It is not compulsory. The seller may, by the terms of the contract or appropriation, reserve the right of the disposal. So this is already made clear to the buyer. It is not something that this is kept in suspense. It is made clear to him. Okay, so let me just read it for you. The seller may, by the terms of the contract or appropriation, reserve the right of disposal of the goods until certain conditions are fulfilled. Until certain conditions are fulfilled. So this is written here very clearly. And then it is mentioned that even after delivery to the buyer or to the carrier, property does not pass until those conditions are met. So even though you will see in some examples that delivery has happened, but still the ownership rights have not been transferred. So this is, again, you have to check the earlier sections and then you have to check section 25 also, whether in any of those cases Section 25 is there. I mean, if seller has any right of reservation, this kind of reservation seller is having, then in that case, ownership will not pass. Whatever you do, ownership will not pass. Okay. So let us see some example. If the example is there and where all it is used, and this is also express and implied. So this reservation can be expressed when you have already made it known to the buyer. So this is express reservation. And in law, there are two situations mentioned which are implied reservation, So let us read them one by one. Let us understand the things, and then we will take the things further. So let's see the example first. X sends furniture to a company by a truck and instructs the driver not to deliver. So till here, let us understand who is X. X is seller, furniture are the goods, and this company is some buyer. So X sends furniture to a company by a truck. So through truck, that means this truck is a carrier, and he has given the instruction to the driver not to deliver the furniture to the company until the payment is made. So normally in 23.2, section 23.2, just now we read that as soon as goods are loaded on the truck, as soon as it has been given to the carrier, ownership will pass to the buyer. But there was something I had specifically, underlined that right of reservation, this disposal rights can be reserved by the seller also. So if some reservation is there, in that case, ownership will not pass. If the reservation is not there, ownership will pass. So let me read it from here completely, and then we will go back to 23.2 again to understand. Okay. So let me read this example again. X sends the furniture to company by a truck and instructs the driver not to deliver the furniture to the company until the payment is made. जब तक payment नहीं मिले, furniture देना मत. The property passes only when the payment is made. So this is a right of this is a kind of reservation which is made by seller, and this is generally known as the reservation on disposal rights or reservation of the disposal rights. Okay, so let me just take you back to that slide where we studied about this 23.2, and here it was specifically written. Here, if you can see, I'll just underline it for you also. It is mentioned does not reserve the right of disposal. If he has reserved the right of disposal, in that case, ownership will not pass. But therefore, if you want to apply 23.2, that means if the goods are loaded to carrier, ownership will pass to buyer. If you want this rule to be applicable, what is the condition with this? The condition is that seller should not reserve his right of disposal. Seller should not have, or seller has not, or seller does not reserve the right of disposal. Are you clear this for this point? Let me quickly have yes or no, whatever the thing is. Yeah, this is conditional appropriation. Deepak has already mentioned. I was about to tell you in the next slide. So this is known as conditional. When you are appropriating, but you are appropriating, putting up a condition, then that is known as conditional appropriation. So wherever section 25 is applicable, we say that this is conditional appropriation. Okay, are others clear? Can I quickly have some yes or no in the chat box, please? Thank you, Ananya, Dakshita. Okay, Pragati. Thank you. So that I can, further take the topic. All right. So we were there on section 25. Here we go. Okay. So section 25 clearly says that the ownership rights can be held by the seller, or the right of disposal can be reserved by the seller, and he may say that until and unless some conditions are fulfilled, he will not pass on the title. He will not pass on the right of disposal. Okay. So this was the example which we have studied. So here it is mentioned, section 25 deals with conditional appropriation as distinguished from unconditional appropriation, which is given in section 23.2. So whatever point was recently mentioned by one of the participants, I think Deepak has mentioned that. So that is given here. Okay. Next, in this paragraph. So we were talking about implied. So here I will just highlight it again for you. It is presumed. Presumed means मान लिया जाएगा, deemed फिर से कुछ चीजें लॉ में मान ली जाती हैं. For example, in this class, I am assuming that you all are understanding the topic. Okay. So here in this particular thing, what we will be reading, there are two situations which are mentioned in the law because the section number is given, section 25 subsection 2 and section 25 subsection 3. Here particular situations are given where it is presumed that seller will have the right of reservation. Even though he has not conveyed, he has not told anything to the buyer, but it will be assumed that he has reserved the right of disposal. So what are those circumstances? Let us read that out. Section 25(2), it says that if the goods are shipped or delivered to a railway administration for carriage and the bill of lading or railway receipt states that the goods are deliverable to the order of the seller or his agent, the seller is prima facie deemed to have reserved the right of disposal. What does it say? You have already loaded the ship either on the railway or on the ship. Okay. So you have loaded the goods, either on the railways or on the ship, and therefore you have this bill of lading or railway receipt. That is the document of title. So whosoever has the document of title will receive the goods. We know this. So normally what should happen is buyer should have this document of title. As soon as he show that document of title, the railway authorities or the captain of the ship will hand over the goods to him. However, there was something mentioned here, this point, to the order of the seller. So they have been strictly instructed that goods shall be delivered or they will be deliverable only to the order of the seller. Whomsoever seller will order will get the delivery. Even though this is the document of title, just by showing the document of title also you will not get the delivery. Until unless we get the instructions from the seller, we will not be able to transfer you the goods. That is what this railway authorities or captain of the ship, they are saying. So if there is any condition that the captain of the ship or the railway authorities cannot transfer the goods or cannot deliver the goods even after seeing the document of title, because it is specifically mentioned that they have to be delivered to the order of the seller only. In that case, it is assumed, it is presumed that seller has reserved his right of disposal. So this is the first point. Second, 25 subsection 3, or we can say that this is the second situation, second implied situation wherein seller will have the reservation right of reservation of the right of disposal. Now read this. Let us see who all can understand this. There the seller draws a bill of exchange on the buyer and sends it together with the bill of lading. So let me just give you the example here. Seller has loaded the goods on the ship, okay, and he has obtained this bill of lading. Now this bill of lading he has to transfer to the buyer so that buyer can take the delivery of the goods, right? So along with this bill of lading, he has made this bill of exchange also. So when the seller is making bill of exchange, obviously he will be making bill of exchange and not the promissory note. Understand? So he is making bill of exchange. Therein he has mentioned that buyer will pay me after 1 month or 2 months, whatever the condition is, and this is the price which he will pay to me. So maybe the buyer has made a verbal promise. He has not given any promissory note or he has not given any written document to say that he will finally pay. So just to be on a safer side, what seller is doing, he himself is drawing a bill of exchange and sending this bill of exchange along with the bill of lading. So what is there in the mind of seller? Seller assumes here that if the buyer signs this bill of exchange, then only I will deliver the goods to the other person, or then only the right of disposal will be given to him. Otherwise, this bill of lading and everything I will take back. There's no use of giving the goods to him because he will not be paying to me. So that is what the intention with which this is decided, and this is how this bill of exchange along with the bill of lading seller is sending to the buyer. Let me read it again for you. Where the seller draws a bill of exchange on the buyer and sends it together with the bill of lading or railway receipt to secure acceptance or payment. What is the intention of seller? Why he is sending this bill of exchange? To secure the acceptance. Secure the acceptance means bill of exchange is normally accepted by the other person. No? If he accepts, that means if he signs on the document, then there is a promise that yes, he will pay. Obviously, in that case, you can make him bound to pay. So it is your intention as a seller. Seller is intending to get that acceptance or the payment directly. That is what his intention is. The buyer must return the bill of lading. If he does not pay or if he does not accept or pay, that is what is mentioned here. That if the buyer is not accepting or accepting that bill of this bill of exchange, then he must return the bill of lading also. He is not supposed to take the delivery. That is what the implied thing is mentioned here. However, if at any point of time buyer wrongfully retains it, the property does not pass. Buyer may also be a smart person. He's taking bill of lading, he's taking bill of exchange also, but he's not signing and giving it back. Normally, the bill has to be signed and given back to the seller. Only then this bill of exchange thing will take place. But what he's doing is he's taking the bill of lading and he's taking the bill of exchange. He's not signing it and giving it back to the seller. So ultimately, what we can say is he's wrongfully retaining those things, because normally he had to sign and give it back, but he has wrongfully retained it with a bad intention that he will anyhow take the delivery of the goods, he will not make the payment. Even if that is the case, even if he shows the bill of lading, he takes the good, the ownership will not pass to him because of this particular condition, because of this particular section 25(3), which says that if at any point of time bill of lading was sent along with bill of exchange and it was not signed and given back to the seller, then in that case, seller reserves the right of disposal. He will not give away his right of disposal. Are you all with me at this section 25? Could you all understand? Either they can say directly, either the seller can expressly convey that I reserve my right, or in these two situations, it will be assumed, it will be deemed that he has a right of reservation. Okay. Yeah, so let me go back because we were here to discuss this. Goods sent on approval basis. Goods sent on approval basis. So how many of you have come across a situation where goods are sent on approval, or it is also known as sale or return basis? Sale or return basis. So let us take an example before directly reading this. Let us take an example and then we will take the theory part. Yeah, sale or return basis. It's not sales return. Normally, sales return means the sale never happened. Okay, it is sale or return. So goods are sent, either they will be converted into sale or they will be returned. Okay, so right now, when the ownership will pass, that is the question, because the whole unit 3 talks about the situations where the ownership will pass. So if there is this kind of sale where goods are sent on approval, okay, when goods are sent on approval, then in that case, when or whose ownership is there, whether the buyer is the owner or the seller is the owner. So that is what we have to discuss. So let us assume an example. Suppose I have taken this pen from a shop and I have told the shopkeeper that let me ask my parents if they are okay with this, then only I will keep this, otherwise I will return it to you. So I have taken it on the condition that if my parents accept it, if my parents gives the approval, then only I will accept this, otherwise I will return it to you. I have not made any payment for the time being. I have just taken this pen. The shopkeeper also says, okay, you can keep that, and but that the one thing which he has mentioned is if you have to return it, please return it by today only. Otherwise, I mean, he has given just 1 day. If whatever you have to decide, you decide in 1 day. Otherwise, I will not take this goods back. Okay, so I told him that okay, it's 1 day is more than enough. I'll ask my parents if they are not ready to take this. I will just return it back to you. The same day I will return it to you. Okay, if it is not a pen, suppose let us take an example of a painting. So that will be more interesting for all of you also to understand. So just replace this by a painting. There is a painting of 7 horses, and this is considered very you know uh, good thing. If you have it in your home, it will give you positive vibes. So seller is saying that way. So if you are attempting for CA foundation, you should have this 7 horse painting with you, so that whenever you write your exams or whenever you are studying for it, you will have good vibes. So but again, you were confused a bit, and you said that let me ask my parents, or let me try it for some time. I will keep this painting at my place, at my house for 3 days. And in 3 days, if I get good result, I will keep the painting. Otherwise, I will return it to you. Okay, so the example is we have taken a painting, we have taken a particular painting, which might be costing, 10,000 or so. We have taken that painting on the sale or return basis. The seller is giving that painting to us, that you can keep that and you can check the results for 3 days. And if you get good results, you can keep that painting. Otherwise, you can just return it to me, okay, without paying me anything. So what happens actually in that case? Suppose we are discussing what will happen about the ownership. So when the painting is given to me on the sale or return basis, at what point of time ownership will pass? So ownership will pass in what situations? Let me just write it for you. So ownership will normally pass when I accept the goods or I approve the goods. Maybe in a day or two itself, I found out that yes, this painting is really very good. It gives very positive vibrations. So I should have it. So I will, as soon as I make the acceptance or I approve, I call the seller that yes, this painting is really good. Even though I have not made the payment, I've simply accepted, I have simply approved it. Then also the ownership will pass. So I'll become the owner. He will not be the owner anymore. So that is the first case. Second situation. So this was the first situation. Let us write the second situation. Second situation is obviously when you make the payment. Without saying anything, suppose you make the payment. As soon as you are making the payment, it implies that you are accepting those goods. You are approving those goods. So that is a kind of implied acceptance or implied approval. So whenever a person is making the payment in case of sale or return, it simply means that he has become the owner. Third thing. Third thing, how the ownership can transfer. There is one more mechanism wherein the ownership can pass in this kind of situation, and that is a retention of the goods. Retention. What do you mean by retention of the goods? The shopkeeper has given me 3 days. Suppose even after 3 days, during the 3 days, I did not say anything. But on the fourth day, there was no message from my side to him. Then in that case, if the painting falls down or if the painting, is damaged anyhow, it will be my loss. Therefore, the seller can claim the whole 10,000 from me. So basically what we are saying is retention basically denotes time period. If we are holding the goods after the time period also, what was the time period given to us? We were given 3 days to check. Even after 3 days, if we are holding the goods with us, it is an indirect affirmation from our side that we are ready to keep the goods. And therefore, it gives the seller the right to claim the money from us. And if we are not paying, he will file a suit for the price. That is the situation in the third point. Now, let us talk about one more situation wherein the property will pass. So, goods sent on approval uh, in this particular fourth case also, the ownership will pass to the buyer. How will that happen? This is mentioned in the form of any act. Any act means any bailment, pledge, or resale. Okay, so let us understand what does this mean. Shopkeeper has given the painting to me, and I am doubtful whether to have it at my place or not. So I handed it over to Samarth. Samarth, please try it at your end. This painting is very good. Just use it for 3 days. Just have it in your study room and let me know the results. At his place, after 1 day or 2 day, a very severe thunderstorm came, and that painting fall down. So what happened was the painting was damaged. The shopkeeper that came to me to ask for the payment. What I will say, I had already given it to other person, so it is not my fault. It is the other person, that is Samarth's fault. It is not my fault. So you want to claim, you claim from him. But the seller will say that I gave it to you, you will have to pay me. So what I will say, I did not accepted the painting. I did not make any payment. I did not retain it because the time period is still there. It is not 3 days yet. The damage has happened even before the 3 days. So what will the seller say? The seller will say that since you have already given it to someone else, you have already bailed it, or you have given it on a pledge, or if you have resold the goods, it indirectly shows that you have accepted the goods and now you have become the owner, and therefore you have to make the payment. So that is also a situation wherein we have to be very, very careful who will become the owner. So these are the 4 points which you must understand and learn for this particular topic. In section 24, it is clearly mentioned that in all these 4 situations, the buyer will become the owner. Other than these 4 situations, there is no other point wherein the buyer will become the owner. In all the other cases, seller is the owner of the goods. Okay. In other case, seller is the owner of the goods. Yes, pledge, payment, they are all mentioned here. Let us quickly read the theory part, and then we will open up for the questions if you have any. So I have stopped sharing the screen. Let me share that. Is my screen visible? We were here. Just let me make it full screen, and this will be the last topic, and then we can have question and answers. So when goods are delivered on approval or similar terms, the property passes to buyer in 3 or 4 situations. One has been clubbed here, basically. So in first situation, it is mentioned when the buyer signifies his approval or acceptance to the seller. So he actually tells the seller that he approves the goods, he accepts the goods, or he does any act adopting the transaction. So we have clubbed 2 points here. So act, I have told you, act means any kind of bailment or pledge. If you are giving away the goods from your side, even though you are not the owner, but you are transferring those goods to someone else. So it indirectly means that you want to keep the ownership, and that is why you are transferring it to other. So therefore the ownership will pass. Next, if he does not signify approval but retains the goods. So second point basically talks about retention of the goods. It talks about retention of the goods. So retention means even after the time period you are holding the goods. So without even informing the seller, you are retaining the goods even after the expiration of the fixed period. Whatever the time was given to you, even after that, if you are holding the goods with yourself and not saying anything, not informing anything to the seller, in that case, the ownership will pass. Third point, he does something to the goods which is equivalent to the acceptance. So equivalent to the acceptance will simply mean that act. This act part was kind of mentioned here also and here also. And there's one more point. If you simply make the payment, that can also be, mentioned, one of the points. If you make the payment, obviously you will become the owner of the goods. There are a few examples. We can read that and then we can close this presentation. He bought a musical instrument on the condition that he would purchase it if he liked it. After a week, he informed the shopkeeper that he agreed to purchase it. Here, the ownership is transferred to the buyer because he has informed it. Next example, A delivered jewelry to B on sale or return basis. B pledged it with C. So though it was given on sale or return basis, he further pledged it. So there is some act which he has done which shows that he wants to keep the goods. Hence, the ownership has been transferred to B by his act. A has no right against C. He can only recover the price from B. So this last line, it suggests that the who can file suit on others. So only the parties to a contract can file suit on each other. So A had delivered the goods to B. So A, that is the seller, can ask the price from B. B in turn can ask the price from C. So that way the chain will go. Next example, A sends B a water motor, okay, on approval in March 2020. B returns it after trial in August 2020. So from March till August, he is having that. The motor was not returned within a reasonable time. Therefore, A is not bound to accept it and B must pay the price. Since it has been long, no? There is around 4 5 months he's keeping that water motor. So therefore, he was supposed to return it. Even if no time period is mentioned, reasonable time will prevail. So reasonable time means at least, after 15 days or 30 days, at least you should have returned. But if you have not, then you have to bear the consequences. That means you will become the owner, you will have to pay the full price. So that is what the point is. If anyone has any question, now you can ask. Your class is done, group. You can leave. If you have no questions, you can leave. Topic is done for the day. Case studies and any kind of questions we will take up tomorrow, the next session, because some more topics are left. So we will cover all the topics, and based on that, whatever questions are asked in the exams also, we will try to cover that. And if you have any specific questions, you can ask me. Thank you so much. Okay. Akshit, if you can unmute, you can ask. Last slide of screen, please. Okay. I've stopped sharing the screen. You want me to share that again? Or we will share that. This has already been shared with you. You can easily download that. It has been shared to you. Should I unmute you? Just a second. Akshit, see if you can unmute yourself. Thank you, Vishnu. Hope you people are doing the assignments also. See, in exams, if you really want to score, you have to practice by writing. It sometimes happens that we are able to explain verbally, but examiner will give you marks only when you write in the paper. Akshit, can you unmute?
हाँ, अब जाके ऑप्शन आया है मैम।
हाँ जी, बोलो बोलो बोलो।
मैम फर्स्ट हैप्पी सीए डे की शुभकामनाएं।
आपको भी जी, बिल्कुल बताओ।
और मैम स्टडी मटेरियल में से मुझे ये पूछना, स्टडी मटेरियल खोल लो, इतने बोलता हूँ।
नहीं, तुम डायरेक्ट पूछो क्योंकि सारे एग्जाम्पल्स हमने लिए हैं। तुम बोलोगे तो मेरे को आ जाएगा समझ में। बोलो।
ठीक है, मैं बोलता हूँ।
इसी
मैम
इसी टॉपिक में से।
पहले यूनिट 2 में है।
अरे तुम कितना पीछे पीछे चले जाते हो बार बार।
आपने कहा था लास्ट में लेंगे, पिछली क्लास में भी बोला था, तो
तो पहले
इसलिए।
अभी आज वाले टॉपिक का पूछो, फिर इसका
हाँ
तुम
हाँ।
अगले में पूछोगे, क्या फायदा। पहले अभी तक वाला पूछो।
हाँ, फिर अगला अनफिट से तो खूब बड़ा है, फिर दिक्कत हो जाएगी। मैम मुझे ये पूछना था, मुझे 3 और 5 में स्टक हूँ, मैं कंफ्यूज हूँ। एक तरफ ये बोलता है ए सोल्ड कारपेट्स टू द कंपनी विच वर रिक्वायर्ड टू बी लेड द कारपेट वाज।
ये मैंने बताया था अभी एग्जाम्पल। अच्छा, इसको इंग्लिश में समझ में आने में दिक्कत है तो एक बार सिंपल सा समझो। मैंने कारपेट खरीदा तुमसे, पर मैंने तुम्हें ये बोला आके लगाना भी पड़ेगा। तो मेरा पूरा कॉन्ट्रैक्ट क्या था, सिर्फ मेरे को कारपेट नहीं चाहिए था, तुम्हारी सर्विस भी चाहिए, एक तरीके से तुमसे लगवाऊंगी मैं, तब जाके आई विल पे यू। ओनरशिप मेरे पास ट्रांसफर ही तब होगी जब तुम वो मेरे को पूरा मेरे यहाँ पे लगा के दोगे। ये कंडीशन थी इसके अंदर। अब बताओ क्या दिक्कत है। वहां पे वो कारपेट शायद चोरी हो गए उस एग्जाम्पल में, ऐसा कुछ है ना। कारपेट्स वर नॉट लेट।
कारपेट वाज नॉट इन डिलीवर स्टेट,
हाँ
आपने बताया था, इतना समझ में आया।
हाँ।
तो उसमें एंड इट वाज नॉट लेट पॉइंट्स में दिक्कत है, वो लास्ट लाइन बता दोगे क्या, एज से
बस
लेके
वो वही,
कंप्लीट।
क्योंकि वो डिलीवरेबल स्टेट में है ही नहीं, ओनरशिप ट्रांसफर ही नहीं हुई। जब आप उसके वहां आके उसको लगाए नहीं, तो एक तरीके से ओनरशिप ट्रांसफर ही नहीं है। ये लिखा हुआ है इसमें।
और एक और था एम इसमें कि एम प्लेस ऑर्डर फॉर हिज बुक विद अ बुक सेलर इन मुंबई, आस्क हिम टू सेंड द बुक बाय करियर, पेमेंट ऑफ द बुक वाज टू मेड बाय चेक, द सेलर सेंड्स द बुक
वो
बाय
रास्ते में
करियर।
चोरी हो गई किताबें, है ना, मिसप्लेस हो गई। अब सपोज तुमने कहीं ऑर्डर किया कोई बुक के लिए, तुमने पेमेंट कर दिया ऑलरेडी, और वो बुक कहीं चोरी हो गई रास्ते में, वो आई नहीं, तुम्हारे पास आई नहीं। तो अब ओनरशिप वाला चैप्टर है ये, हु इज द ओनर, हु विल बेयर द लॉस, ये वाली बात है। तुम तो क्या बोलोगे, सेलर को बोलोगे मैंने तो पेमेंट कर दिया था, मुझे या तो मेरे पैसे वापस दो या फिर मुझे मेरी किताबें दो। सेलर क्या बोलेगा, मैंने तो किताबें भेज दी थी, मेरी तरफ से तो चली गई। तो लॉ में तो यही लिखा हुआ है कि किताबें जैसे ही उसने कुरियर वाले को दी, ओनरशिप हैज बीन ट्रांसफर्ड। अब रास्ते में कुछ भी होता है, उसकी जिम्मेदारी किसकी मानी जाएगी, बायर की। प्रैक्टिकली थोड़ा सुनने में अजीब लगता है, पर लॉ में ये है फैक्ट।
लॉ की लैंग्वेज में एप्लीकेबल है।
हम्म।
और बस एक है इसमें, फिर यूनिट इसमें मैंने पढ़ा था कल बुक में, व्हेन इंसिग्निया अप्रूवल एक्सेप्टेंस ट्रेलर समझ
मुझे
में
एक
आ
नेक्स्ट
गया।
क्लास में याद दिलाना अक्षय, तुमने ही बोला तो मुझे ध्यान आया, अपन इंश्योरेंस वाला थोड़ा सा डिस्कस करेंगे, बिकॉज नॉर्मली व्हेन वी सेल द गुड्स टू फ्रॉम वन प्लेस टू अनदर प्लेस, ये जो दिक्कत होती है ना, रिस्क होता है, इस रिस्क को कवर करने के लिए इंश्योरेंस करवाते हैं गुड्स का।
ठीक है,
तो
ये
दैट
दो
इज
मैं
अगेन।
ठीक है, सी और डी पॉइंट में मैं इसको दोबारा पढ़ के अगली क्लास में पूछूंगा, यूनिट टू
ठीक
से
है,
पूछता हूँ, वरना
ठीक है।
यूनिट टू से पूछता हूँ। ये
हम्म,
कट कट कर देते हैं, अगली क्लास के रखते हैं, फिर
हम्म।
जेन्युइन डाउट से जो है। मैम, सेल यूनिट टू में
संदीप,
मुझे।
एक मिनट में बताती हूँ, पहले एक बार अक्षत को क्वेश्चन कर लेने दो, फिर तुम्हारा
हाँ
भी ले लेते हैं। हाँ
हाँ हाँ,
बोलो।
वरना ये रह जाएगी फिर अगली क्लास में, और
हाँ
दिक्कत
हाँ,
लंबा
बोलो बोलो
टॉपिक।
बोलो
हाँ,
आराम से।
यस 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 यस। एग्जाम्पल इसमें, हाँ, एग्जाम्पल 5 और उसका उससे पहले पैरा।
तुम तो
Thus it
क्वेश्चन
has
बोलो,
the
जो लिखा हुआ है, मेरे पास खुला हुआ नहीं है ना कुछ भी।
स्टडी मटेरियल में से बोल रहा हूँ
हाँ
मैम।
बोलो।
इफ ए सेल्स टू बी टिन्स, एक एग्जाम्पल है और एक छोटा सा पैरा, बस छोटा। इफ ए सेल्स टू बी ऑफ कंडेंस्ड मिल्क labeled CDF brand, and
हाँ
this is
ये
proved
हमने,
to।
अच्छा मैं बता देती हूँ उसमें क्या था।
हाँ
तुम एक कंडेंस्ड मिल्क बनाते हो, ठीक है, तुम ऐसे समझो ना, कोई भी तुम मिल्क का, कंडेंस्ड मिल्क जो होता है वो तुम बनाते हो, ठीक है सपोज। पर तुम खुद का, तुमको लेबल अपना ब्रांडिंग तुम्हारे खुद के नाम से करनी चाहिए थी, पर तुमने सरस के नाम से ब्रांडिंग कर दी, सपोज अमूल की या सरस की ब्रांडिंग उस पर कर दी। तुम क्या ये गुड्स मुझे सेल कर सकते हो, तुम तो करना ही चाहते हो, लेकिन क्या तुम ओनर हो उस चीज के, क्या तुम ये कर सकते हो, टाइटल ही नहीं है ना तुम्हारा। यू योरसेल्फ आर नॉट द ओनर ऑफ दोज गुड्स, क्योंकि ब्रांड तुम्हारा नहीं है, तो तुम फ्रॉड करने की कोशिश कर रहे हो। तो ये उस वाले टॉपिक पे आ जाता है, जहां कंडीशन वाली चीज है, दैट बायर कैन रिटर्न द गुड्स, ये बोल के कि क्योंकि टाइटल ही नहीं है आपके पास, इस तरह के गुड्स बेचने का टाइटल नहीं है, बिकॉज ब्रांड इज नॉट योर्स, ऐसा, क्योंकि
जब
अमूल वाले तो केस
तो,
करेंगे ही।
तो मैं ये पूछना चाह रहा हूँ, जैसे केस स्टडी कल मैं देख रहा था, आपने
हम्म।
वेद दी थी, तो उसमें और प्रीवियस ईयर क्वेश्चन पेपर में एक कंफ्यूजन रह जाता है कई बार, उसमें सेल बाय सैंपल अप्लीकेबल है या सेल बाय सैंपल डिस्क्रिप्शन।
पहले देखो क्वेश्चन में क्या बोला है, सैंपल दिखाया, सिर्फ सैंपल दिखाया, कुछ बोला नहीं, तो हो जाता है सेल बाय सैंपल। सैंपल दिखाया, उसको थोड़ा सा डिस्क्राइब भी किया, तो सेल बाय सैंपल एंड डिस्क्रिप्शन दोनों लगे।
तो शॉर्ट में मतलब एग्जांपल बता दोगे एक से, सैंपल और डिस्क्रिप्शन।
मैंने ऐसे दिखाया कि मैं इस तरह के पेन आपको बना के दूंगी,
यस
बस
मैम।
मैंने और कुछ नहीं बोला है ना, मैं इस तरह के पेन आपको बना के दूंगी, ये सैंपल दिखा दिया बस तुमको। तो अब जो बल्क प्रोडक्ट तुम्हारे पास आएगा, यू कैन मैच इट विद सैंपल, और उस तरीके से हो जाएगा। ये एक लिखा हुआ है, अगर सेम नहीं होता देन यू कैन रिटर्न। सेल बाय सैंपल एंड डिस्क्रिप्शन में क्या होगा, मैंने ये पेन बताया, ये पेन ऐसा भी है, और फिर मैं बता भी रही हूँ कि चलता है, तो इसमें ब्लू इंक भी हो सकती है, रेड इंक भी हो सकती है, मैं अलग अलग इंक भी यूज कर रही हूँ, या जो भी इसकी बहुत फाइन राइटिंग आएगी। तो मैंने इसको जैसा डिस्क्राइब किया था, जो मेरे पास बल्क प्रोडक्ट आएंगे उसमें मैं पेन चला के भी देखूंगी कि ये वाकई में फाइन राइटिंग वाले हैं या नहीं। तो एक तो होता है सिर्फ लुकिंग, एक है वाकई में जो डिस्क्राइब किया था वैसे ही उसमें चीजें, क्वालिटीज या जो भी बोला वो सारी चीजें हैं कि नहीं है, तो ये
इसका
दोनों आते हैं।
मतलब इसका मतलब ये, जैसे गुड्स फ्री है बिना डिफेक्ट के रेंडरिंग करते हैं अनमर्चेंटेड विच वर नॉट अनपेरेंट रीजनेबल एग्जाम आपने बताया था सैम्पल कंडीशन तभी अप्लीकेबल होगी अगर डिफेक्ट होगी। और एक तरफ इसमें ये होगा कि इम्प्लाइड कंडीशन की बल्क सप्लाई होगा और बहुत सैम्पल डिस्क्रिप्शन होंगे केस में। तो सैम्पल दोनों के केस में होगा कि किसी एक ही केस।
तुम्हें पता है तुम क्या क्या बोल गए इतना सारा। पहले एक
मैं
बार।
दोबारा बोलता हूँ तो कोई
हाँ।
नहीं आराम
हाँ।
से क्योंकि ये केस
हाँ।
स्टडी में आता है।
आराम से
हाँ
बोलो, पूछना तो है ही,
आराम
पूछ
से।
लो। पूछ लो।
हाँ आराम से करते हैं फिर कंफ्यूज हो जाएगा मुझे। गुड द गुड्स आपने बताया था तो मैंने पढ़ा भी था द गुड शैल बी फ्री फ्रॉम एनी डिफेक्ट रेंडरिंग देम विद अनमर्चेंटेबिलिटी
चलो अब
विच।
एक बार पहले सिंपल, पहले डिफेक्ट ही दो तरीके के होते हैं, हमने डिस्कस किया था। एक होता है पेटेंट डिफेक्ट, एक होता है लेटेंट डिफेक्ट। अब तुम मुझे बताओगे व्हाट इज पेटेंट एंड व्हाट इज लेटेंट, बस इतना सा बता दो।
लेटेंट डिफेक्ट मतलब किसी प्रोडक्ट में मतलब डिफेक्ट है। लेटेंट डिफेक्ट का मतलब होता है किसी प्रोडक्ट में डिफेक्ट मतलब जैसे एक्सपायरी डेट या कुछ भी चेक करते हैं
डिफेक्ट
तो।
तो दोनों ही है, डिफेक्ट तो दोनों ही है। पेटेंट डिफेक्ट भी डिफेक्ट में आएगा, लेटेंट भी बाद में आएगा, लेकिन दोनों का मतलब क्या है मैंने समझाया था, अब बताओ देखिए। पेटेंट डिफेक्ट जो डिफेक्ट देखते से ही पता लग जाएगा। भाई इस पेन में अगर मान लो ये ढक्कन नहीं है ना, ये ऐसा ही पेन है, पर मुझे तो नॉर्मली पेन में होना चाहिए ढक्कन, ऐसा अपन अज्यूम कर लेते हैं अभी एक बार। तो ये एक तरीके से डिफेक्टिव है, मुझे तो दूसरा पेन चाहिए जिसमें कि ढक्कन हो, या ठीक है लिड हो उसका, एक तरीके से। या अब मैंने एक एग्जांपल दिया था बुक का। बुक में अगर कवर पेज पे तुम्हें दिख जाए ये तो पुराना एडिशन है, तो वो डिफेक्ट है, पेटेंट डिफेक्ट, देखते ही समझ में आ गया। ठीक है, या उसमें कोई छेद है, दैट इज पेटेंट डिफेक्ट। लेटेंट डिफेक्ट क्या होता है? ऐसा डिफेक्ट जो मेरे को देखने से दिखाई नहीं दे रहा, जब मैं उसको यूज करूंगी तब मुझे पता चलेगा। तो जब मैं बुक को पढ़ने लगी तब पता लगा उसमें से बीच में 4-5 पेजेस ही मिसिंग है। तो वो स्टोरी पढ़ते पढ़ते समझ आया, अब इसके बाद के तो पेजेस ही नहीं है। तो फिर वहां पे वो लेटेंट डिफेक्ट हो जाता है। अब तुम अपने आप को अज्यूम करो, तुमने वो बुक खरीदी, ठीक है,
इसमें
पुराने एडिशन की तुमने बुक खरीद ली, पैसे दे दिए शॉपकीपर को, तुम घर ले गए बुक। घर जाके तुम्हें पढ़ा और पता चला अरे ये तो पुरानी बुक आ गई। सेलर के पास वापस जाओगे रिटर्न करने के लिए, सेलर ले लेगा क्या वापस? अच्छा होगा तो ले लेगा, नहीं तो रूल क्या है? क्योंकि तुम खुद देख के गए थे, तुमने खुद पसंद किया था, पेटेंट डिफेक्ट अगर था तो तुम वही मना कर देते। तो वहां पे सेलर इज नॉट बाउंड टू टेक द गुड्स बैक। ठीक है,
क्या
लेट द बायर बिवेयर लग गया वहां पे एक तरीके से।
क्या बायर अवॉइड कर सकता है कॉन्ट्रैक्ट?
बायर कैसे करेगा? अवॉइड नहीं कर सकता ना, उसने देख के ले लिया। ही कैन नॉट, ही कैन नॉट, ये वाली चीज हो गई। अब ऐसे ही उधर जाओ लेटेंट डिफेक्ट पे। अब तुम बोलोगे कि ये बुक में बीच में पेजेस गायब थे, मैं कैसे बताता? उसमें सेलर को गुड्स को लेने ही पड़ेंगे वापस। ही विल हैव टू टेक द गुड्स बैक। तो ये उसकी वहां कंडीशन हो गई। तो मर्केंटेबल में ये दोनों चीजें बताई हुई है कि लेटेंट डिफेक्ट्स में तो आप गुड्स को रिटर्न कर सकते हो, पेटेंट डिफेक्ट्स में तो बायर की रिस्पॉन्सिबिलिटी है उसको देख के गुड्स लेने चाहिए। देयरफॉर द गुड्स कैन नॉट बी रिटर्न, कॉन्ट्रैक्ट कैंसिल नहीं होगा।
ठीक है सैंपल का कंफ्यूजन मेरा क्लियर हो गया। अब वो डिस्क्रिप्शन था उसी पॉइंट में। डिस्क्रिप्शन में जैसे मतलब ये
अब
था
एक बार मैं
कंफ्यूजन।
संदीप का क्वेश्चन ले लेती हूँ।
हाँ हाँ
संदीप इज
फिर
आस्किंग।
आप
हाँ कोई
हाँ फिर
बात नहीं।
डिस्क्रिप्शन बता देना मैम ठीक।
हाँ, संदीप पूछ रहा है मैम हाउ टू लर्न द प्रोविजंस फॉर अ लॉन्ग टाइम एंड ऑल्सो सजेस्ट मी आफ्टर प्रैक्टिस ऑफ एनी क्वेश्चन व्हाट डू आई डू। ठीक है, तो सबसे पहले हमें क्या करना चाहिए? जो भी हमने पढ़ा, इट इज फॉर ऑल ऑफ द स्टूडेंट जो भी अभी अटेंड कर रहे हैं। हाउ टू प्रैक्टिस एंड हाउ टू मेमोराइज द लॉ पोर्शन, बिकॉज व्हेन यू लर्न द थिंग्स बहुत इजी लगता है और समझ में आ जाता है, बट हम जब 2-3 दिन बाद उसको पढ़ेंगे, व्हेन वी रीड इट आफ्टर सम टाइम, at that point of time we realize that we do not remember each and every provisions. Or basically it happens like we might be remembering the concept but we don't remember the sections or the exact terms which are used in law. So how to remember all that? Just make a list of sections, important sections. I'm not saying that you write all the sections because that will require a lot of time. What you can do is, for every chapter just note down 5 or 6 very important topics and their sections which are coming again and again in the examinations. At least remember those and just write that on the top of the chapter itself, so that whenever you are opening that chapter, whenever you are reading that chapter, those will be there for you. And one more thing what you can do is, you just make a list of those important terms and sections and place it on your study table. रोज आते जाते आप उसको देख सकते हो, अपने आप sections learn हो जाए। See, it is a matter of practice. You cannot remember everything every time. So if you make it a habit to just go through it once a day, every day, just once, For 5 minutes, I have to just check the sections and check the terms, whichever there are in law, because there are other subjects also. You have to read so many subjects. So for law, I won't ask you to spend a lot of time. It's just that make it a habit to make some important points or make some important notes for yourself. Just put it on the study table, just in short form, so that you understand that and you remember that in a longer duration also. And just practice by writing. It is very important. बिना written practice के law में marks नहीं ला पाओगे आप. Because we assume that we will be able to write an exam, but you never know what to write in case study, how to write in a case study pattern questions. So you have to practice, you have to mention proper sections. If you remember the section, then only mention, otherwise don't quote a wrong section. Marks will be deducted otherwise.
डिस्क्रिप्टिव डिस्क्रिप्शन के केस में इसी पॉइंट का ही है, डिस्क्रिप्शन के केस में कोई इम्प्लाइड
डिस्क्रिप्शन
कंडीशन।
अक्षित सिर्फ इतना सा है कि अगर मैंने कोई चीज मैंने बोला, जैसे शॉपकीपर अगर बोलता है ये बासमती चावल है, उसने डिस्क्राइब करके दिया है ना, बासमती चावल बोला उसने, तो बासमती चावल आपको पता नहीं था, मम्मी ने भेज दिया जाओ लेकर आओ बासमती राइस, एंड यू वेंट देयर एंड यू आस्क्ड द शॉपकीपर टू गिव यू बासमती राइस, शॉपकीपर सेड यही होता है बासमती चावल, यही है ले जाओ। मम्मी ने घर जाके कहा ये तो नहीं है, कैन यू रिटर्न द गुड्स? यस यू कैन रिटर्न, बिकॉज सेलर ने वो गलत डिस्क्रिप्शन देके आपको भेजा था। आर यू गेटिंग माई पॉइंट? जो भी
यस
बोला
मैम।
वैसा अगर गुड्स नहीं है आप रिटर्न कर सकते, बस ये इतना सा होता है। बहुत ज्यादा इसको ऐसे कंफ्यूज मत करो, कहाँ पे क्या। एग्जाम्पल से इजीली समझ में आ जाएगा कौन से टॉपिक के लिए बोल रहे हैं,
एक बार
अपने आप
शिप
उसमें।
वाला शिप
हाँ
वाला
बोलो,
बता दो। शिप वाला बता दो एग्जाम्पल, शिप
ट्रिप
वाला
में क्या है
कोलकाता।
बोलो, बोलो क्या है।
एक ही एग्जांपल है इसमें, ए एट कोलकाता शिप आएगा अभी, ए एट कोलकाता सेल्स टू बी 12 बैग्स ऑफ वेस्ट सिल्क ऑन इट्स वे फ्रॉम मुर्शिदाबाद टू कोलकाता। There is an implied condition that silk shall be such as is known as in the market as waste silk. If it is not, B is entitled to reject the goods. A ship was contracted to be sold as copper fastened vessel, but actually it was only partly copper fastened.
अब ये
Held
तुम ही
that
बता
goods
दो, जो बोला वैसा तो है नहीं, उसने मिक्स करके भेज दिया, तो रिटर्न कर सकते हैं ना गुड्स।
held that goods did not correspond to description and hence could be returned, or if buyer took the goods he could claim damages for
एकदम
breach.
सिंपल एग्जाम्पल्स है अक्षित, कंफ्यूज मत हो, इतना सिंपल सा लिखा हुआ है, देखो बोला क्या था, भेजा क्या है, कुछ और ही भेज दिया उसने, दैट इज व्हाई दीज गुड्स कैन बी रिटर्न। तुम उसमें लैंग्वेज में कंफ्यूज होते हो या कहाँ कंफ्यूज होते हो, उसको एकदम
वो
सिंपल पहले
वो कंफ्यूज हो
पढ़ने से
जाता है।
पहले माइंडसेट ये बनाओ कि मुझे आता है ना, आई नो एवरीथिंग, आई विल बी एबल टू अंडरस्टैंड दिस एग्जाम्पल। उसको कॉम्प्लिकेट मत करो, है ना, हर को बहुत ज्यादा कॉम्प्लिकेशन से सोचोगे तो फिर वो डिफिकल्ट हो जाएगी चीज। आप सिंपल, इसको सिंपल एग्जाम्पल है, जो बोला वैसा भेजा ही नहीं, तो ऑब्वियसली गुड्स कैन बी रिटर्न। अब वो रिटर्न किस वजह से हुए, अब उसको आइडेंटिफाई करो, अंडर विच पॉइंट यू कैन टेक दैट अप, वो सेकंड स्टेज आएगी। पहले ये तो समझो गुड्स रिटर्न हो भी सकते हैं कि नहीं हो सकते। अगर गुड्स रिटर्न हो सकते हैं तो इम्प्लाइड कंडीशन। नाउ विच इम्प्लाइड कंडीशन? क्या वो टाइटल है, क्या वो डिस्क्रिप्शन है, क्या वो सैंपल है? क्योंकि सैंपल तो दिखाया ही नहीं था, बोला था सिर्फ ना, तो जहां बोला वहां पे डिस्क्रिप्शन आ।
डिस्क्रिप्शन से गुड्स करेस्पॉन्ड हो सकते हैं।
हम्म।
तो मुझे क्या होगी डाउट क्लियर। तो मुझे मतलब जैसे मैं पढ़ता हूँ, जैसे कोई भी डायरेक्ट क्वेश्चन आता है या एप्लीकेशन आता है, तो कई बार जैसे कंफ्यूज ना हो तो सिंपल वे में हम पॉइंट्स लिख सकते हैं और
आराम से
एग्जांपल।
आराम से, लॉ में अपने ऐसा कहीं भी नहीं है कि आपको बहुत टेक्निकल लैंग्वेज यूज करनी है। जब पास होना जरूरी है, पहली बात तो पास होना जरूरी है, और जो बच्चे को ऐसा लगता है कि हाँ वो तो मैं आसानी से पास तो हो ही जाऊंगा, देन दे शुड गो फॉर द टेक्निकल लैंग्वेज। तो हर एक बच्चे का लेवल होता है, आप बहुत ज्यादा अपने आप को प्रेशराइज मत करो। लॉ के एग्जाम को क्लियर करने का सिंपल सा फंडा होता है दैट firstly you should understand the concept. If you are able to write the concepts in simple English, then also it is okay. पर वो कहीं कहीं टर्म्स आपको, लीगल टर्म्स जो होते हैं वो यूज करने पड़ेंगे। डेफिनेशन के टाइम पे डेफिनेशन हैज टू बी एग्जैक्ट डेफिनेशन जो लॉ में दिया हुआ है, वो आप अपने मन से नहीं बना सकते। एग्जाम्पल्स आप अपने मन से बना सकते हो, आप जो थ्योरी पार्ट है वो थोड़ा सा अपने मन से बना के लिख सकते हो, प्रोविजन आप अपने हिसाब से, क्योंकि मुझे जो समझ में आया मैंने वैसे बताया, ठीक है। वो लैंग्वेज यू कैन चेंज, इट इज नॉट दैट यू कैन नॉट चेंज द लैंग्वेज, मतलब इट हैज टू बी प्रेजेंटेबल। अभी फाउंडेशन में बहुत ऐसा मार्क्स नहीं कटते हैं इस चीज के कि आपने बिल्कुल ही अलग लिख दिया तो ऑब्वियसली कट जाएंगे, तो यू हैव टू बी फर्स्ट ऑफ ऑल वेरी मच श्योर वॉट एवर कॉन्सेप्ट यू हैव अंडरस्टूड, तो कॉन्सेप्ट को आप अपने भाषा में लिख दो, सिंपल।
एग्जाम्पल्स के लिए मार्क है क्या मैम? इम्प्लाइड कंडीशंस अगर आ गई, डायरेक्ट क्वेश्चन या
आपको
इम्प्लाइड
हमेशा
मार्क?
लिखने चाहिए एग्जाम्पल्स तो हमेशा लिखने चाहिए। क्यों? हर टॉपिक के बाद एग्जाम्पल क्यों होता है? जिससे समझ में आए। आप एग्जामिनर को ऐसा ही सोचो कि मैं उसे समझा रहा हूँ, फ्रॉम दैट पॉइंट ऑफ व्यू यू आर टीचिंग और यू आर राइटिंग द एग्जाम्स बेसिकली। तो कोई भी क्वेश्चन आएगा बिना पूछे भी आप एग्जाम्पल्स दोगे तो वो बेटर होता है हमेशा, whenever you are
थैंक यू,
putting the example।
थैंक यू मैम फॉर गाइडिंग अगेन है। सी डे की शुभकामनाएं, ये सफल रहे सितंबर 2026 में सबके लिए।
आप सबके लिए भी बन जाओ, जल्दी जल्दी से बन जाओ सर।
और थैंक यू, इतनी अच्छी पीपीटी थी, खूब अच्छे एग्जाम्पल थे, समझ में आ गए। और असाइनमेंट भी करे थे, बहुत इजी थे क्वेश्चंस, यूनिट वन
हो
के, यूनिट
जाएंगे,
टू
सब
के।
इजीली हो जाएंगे। और भी क्वेश्चंस आप ट्राई करोगे ना, जो भी मॉक टेस्ट पेपर्स या जो भी अभी आरटीपीज वगैरह अपलोड होती हैं, सारे आप लोग ट्राई कर सकते हो। सिर्फ थोड़ा सा स्पीड से करो। आप एक ही सब्जेक्ट पे बहुत ज्यादा टाइम लगाओगे देन यू विल वेस्ट योर एनर्जीज।
वही बैलेंस करना पड़ता है चारों
हाँ,
सब्जेक्ट
बैलेंस
को।
करना पड़ेगा, टाइम टेबल बना के फिर पढ़ाई करना पड़ेगा। हर सब्जेक्ट का वेटेज है, हर सब्जेक्ट के मतलब पास होना जरूरी है ना हर एक में, अकॉर्डिंगली यू
हाँ,
विल हैव टू स्टडी।
अकॉर्डिंगली सब में 70 80 इतने लिया हो, ठीक है, 70 70 इक्वली लिया हो तो।
70 ले आएंगे तो तुम्हारी रैंक आ जाएगी।
हाँ।
ठीक है।
और लास्ट डे जब होगा तब आप सजेस्टेड आंसर्स करवा दे।
ओके ओके ठीक है, ओके, आई एम जस्ट क्लोजिंग द सेशन, थैंक यू।
थैंक यू, थैंक यू, इट वाज
ओके,
नाइस।
बाय।